Subcommittee will come to order. Good morning. It is with a sense of purpose as well as a sense of urgency that we gather here today to consider some sensible ways to make the Consumer Product Safety Information Act, also known as SIPSIA, work better for all Americans. There is bipartisan agreement that SIPSIA, while well-intentioned, has created a number of serious problems for manufacturers and retailers. Today we will examine some ways to make a good law even better. The Chair will now recognize herself for an opening statement. Can you start me back at 5? Thank you. In our first hearing of the year, we heard about many of the problems associated with passage of SIPSIA. Today, we will focus on a preliminary discussion draft which offers a range of possible solutions. One major area for reform relates to the regulation of children's products. In this area, we have the benefit of 5 unanimous recommendations from the CPSC. We also have draft legislation from last year and other CPSC suggestions in response. The discussion draft aims to reduce the regulatory burdens of the law without undercutting consumer protection. A fundamental premise is that the Commission can actually protect consumers far better when it is allowed to set priorities and regulate based on risk. Where possible, we should spare the Commission from having to make time-consuming, case-by-case determinations and let it spend more time on its bigger problems. This is especially true in our current budget climate, where we have to make the best use of agency resources. We need to strike the right balance, and that is seldom easy. The discussion draft points to areas where we must decide important policy questions. I hope our witnesses today will help us to make wise choices by shedding light on these issues. In Section 1, for example, the draft leaves open the age for defining the term children's product. At our last hearing, my friend and colleague, Mr. Dingell, the Chairman Emeritus of the full committee, reminded us that a lot of the problems with SIPSIA originated in the Senate, but this is one that did not. The Senate-passed bill applied the lead content limits to products for children ages 7 and under. That age would have kept the focus on children who are at greater risk when it comes to lead, because very young children, according to the CPSC, are much more likely to put things in their mouth. The House set the top age at 12 years old because of the so-called common toy box concern. But by pushing the age to 12, we ended up regulating a huge number of products that are never going to be mouthed or even handled by young children. These include not only the well-known examples of ATVs, bicycles, and books, but also band instruments, scientific instruments, and clothes for older children, among other things. Another key area is third-party testing. Again, the discussion draft tries to strike an appropriate balance. It preserves third-party testing for lead paint, cribs, pacifiers, small parts, and children's metal jewelry, all priorities that Congress explicitly set in SIPSIA. For other standards, however, it gives the Commission discretion to decide what standards should require third-party testing, and it gives the Commission new authority and flexibility to require testing for only some portions of a standard or only for certain classes of products. It also asks the Commission to make sure that the benefits of third-party testing justify the costs before making it mandatory. Another major area of reform is the CPSC's public database, which just recently began to post complaints. The discussion draft addresses some of the more significant problems that were brought to light in our earlier hearing. First, the draft spells out in greater detail who can submit reports of harm for the public portion of the database. Among consumers, only those who have suffered harm or a risk of harm, as well as members of their family, legal representatives, or any person authorized by the family, could make public reports. Second, the draft sets forth a process for improving product identification. The database cannot help consumers if they don't know which products have problems. The draft enlists manufacturers to help consumers provide better descriptions. Third, the draft gives CPSC more options for solving claims of material inaccuracy. The fundamental premise here is that the database may do more harm than good if it misleads consumers based on inaccurate information. Finally, the draft would strengthen the Commission's authority to investigate complaints. While some consumers may benefit from the ability to see safety-related complaints, a lot more consumers will benefit if the Commission can investigate complaints more quickly. Congress must move quickly, too, because the clock is ticking. Unless we act soon, the 100 parts per million lead limit will take effect retroactively in August, and once again, millions of dollars worth of products will become illegal to sell, donate, or export. We have an opportunity and an obligation to make SPSEA a law that benefits all Americans. And now I would like to recognize the ranking member of the full committee, Mr. Waxman, for his 5-minute opening statement.
Chairman Bono, thank you very much for recognizing me to give this opening statement, and Mr. Butterfield to allow me to go ahead of him. I share your belief that some changes are needed to the toy bill that we passed in 2008. That legislation was an historic step forward for children's safety, but like most legislation, it was not perfect. It has had some unintended consequences and needs refinement. But the discussion draft before us, which is the subject of today's hearing, takes a wrecking ball to the law and would endanger young children. As the chair of the Consumer Product Safety Commission wrote us today, this draft would turn back the clock to an era when harmful products made their way into the stream of commerce and into the hands of innocent children. In 2008, our committee led the way in passing a strong toy safety law. We held hearings at which we learned about children who died or were severely injured by lead in toys and small charms. We learned that other children suffered catastrophic internal injuries from magnetic toys that ripped through their intestines. And we witnessed record recalls and loss of confidence in the safety of children's products. Despite strong bipartisan support for the new law, implementation has not always been smooth. The ATV industry, the bicycle industry, the publishing industry, and makers of handcrafted toys have all raised valid compliance issues. I know it's possible to address these concerns without gutting the law. When I was chairman of the committee in the last Congress, we initiated a stakeholders process that produced a draft bill that gave targeted relief to industry while maintaining the most important health and safety protections in the new law. That draft legislation was supported by both industry and consumer groups. Although the Republican staff were consulted at every step in the process, Ranking Member Barton decided he would not support the bill, and we never acted on it. The discussion draft before us is a very different document. Democrats, consumer groups, and health experts were not consulted. The result is a one-sided proposal that provides relief to industry, but sacrifices children's health and safety. According to the Consumer Federation of America and Consumers Union, this proposal undermines safety testing for children's products, undermines lead protections, undermines the effectiveness of the new crib safety standard, and undermines the new public safety product hazard database. According to Chairman Tenenbaum and Commissioners Adler and Moore, this proposal would be a reversal of several of the core safety provisions in the law. But they're, not only are they critical of the bill, but let me just state quite clearly, there's no chance that a bill this extreme could ever become law. It would not survive in the Senate, and if it did, it would be vetoed by the President. The result would be a lost opportunity. Many of the witnesses who will testify today have identified legitimate concerns, but they will receive no relief if all we produce is a more partisan gridlock kind of legislation. If we work together, I am confident that we can find a way to address most of industry's concerns without jeopardizing the important safety advances we made in the toy safety law. And I had a discussion with the chairman yesterday. I think there's an opportunity for us to work together and produce a product that will be a consensus product. I hope that after this hearing is over, we can start fresh and we can produce a genuine bipartisan reform we all can support. Madam Chair, I'd like to yield the rest of my time and an additional 1 minute without any objection to Mr. Rush, who chaired this subcommittee in the last Congress and I think has an important statement to make.
Without objection. The gentleman is recognized.
2 minutes.
Thank you, Madam Chair, and I want to thank the ranking member for the full committee for yielding this time to me. Madam Chair, consumer protection is one of the core functions of this subcommittee, and I want to commend you for convening this important hearing. However, I'm surprised to see that instead of talking about improving safety for our children, making our new laws implementation possible, we're focusing on undoing one of the legislative achievements of this subcommittee historically. Demolition and destruction, not creative solution, seems to be the policy agenda for our new Republican majority. I'm still waiting to see when we will talk about real policy solutions, including the policy issues, the implementation issues, as it relates to this bill for the American people. Regulations are not a problem. It is the constant changes or the risk of changes that are difficult to manage for our manufacturers, our consumers, and for the American public. We need to agree once and for all and implement the laws that we have developed. We need regulatory predictability. The Consumer Product Safety Improvement Act that the Republicans are attempting to revise today represents demolishing the most comprehensive overhaul of U.S. consumer protection oversight in a generation, one that established policies which repaired our nation's broken product safety system. And I must say, Mr. Chairman, Madam Chairman, that I am very proud of what we did with bipartisan input, with input from all the stakeholders, despite the political differences that we all shared. We were able to reinvigorate the CPSC with resources. We added additional commissioners. We authorized a shiny new testing lab. And Madam Chair, could I ask for an additional 30 seconds?
The clock was...
Okay, all right. Well, Madam Chair, I just want to conclude by saying that this hearing could be better spent if we were really trying to maybe solve some of the problems that we have implementing the bill.
All right, so the gentleman yields back.
I yield
and now,
back the time I have.
Chairman Upton, in accordance with the committee rules, yielded me his 5 minutes, and as his designee, I would like to recognize the Chairman Emeritus of the full committee, Mr. Barton, for 2.5 minutes.
Well, Madam Chairman, I really can't do it in 2.5 minutes. So you're going to have to give me at least 3 minutes or just go to somebody else.
Well, we were rather lenient with the other side, so that's not a problem. Go ahead.
Madam Chairman, I will yield the Chairman Emeritus my time.
So the Chairman Emeritus is recognized for 3.5 minutes.
There is an old joke about somebody trying to get somebody to vote for them, and the guy says, "I'd never vote for you if you were running unopposed." And the man goes back and says, "Well, how do we put that voter down?" He says, "Put them down undecided." That's kind of what we need to put Mr. Waxman down after what he said. I participated as the ranking member when this bill was passed. I participated in the last Congress when there was an attempt to amend it. When Chairman Waxman said that the Republicans and the staff were consulted, that's a true statement, but we weren't listened to. In the last Congress, Chairman Waxman and his allies were almost totally unflexible in trying to come to some common ground on changes to the law that was passed under Chairman Dingell's chairmanship back in 2008. This discussion draft does not take a wrecking ball to the law. It's a good faith attempt to reconcile a law that in its current state is literally unenforceable. We have that in testimony from the Consumer Product Safety Commission. They have basically I wouldn't even use the word, the term basically, they have no flexibility at all. The discussion draft that Chairwoman Bono Mack has crafted does give flexibility. I think that's a good thing. It does change some of the principles or modify some of the principles from the law that was passed 2 years ago, but it keeps the core of the law together, and it does give the Commission the flexibility and the industry that has to live by it the ability to actually use a little common sense in implementation. I think that's a good thing. I think this discussion draft is a vehicle that can be a bipartisan compromise, but a compromise means both sides have to come together. And Chairman Waxman's statement indicates to me that it's the bill or nothing. And I don't think that's a position to take when we're trying to do something that should be everybody's best intentions to actually protect the children of America, but also give those that provide the products for our children the ability to provide them in a safe and effective fashion. I'm the father of a 5-year-old and the grandfather of 5 grandchildren that are under the ages of 13. There's no way in this world that I want to do anything that would put my 5-year-old child or my grandchildren in harm's way. So, Madam Chairwoman, I think the discussion draft is a good starting point. It is a starting point. It is not an end point. And if Mr. Waxman and Mr. Rush and our friends on the minority side wish to work with us, we can come up with something that improves the bill that's now the law and gives the flexibility that's necessary. So with that, I want to thank the chairwoman for giving me some extra time and thank the vice chairwoman, Ms. Blackburn, for giving me some of her time, and I yield back.
Thank the gentleman for his statement and yield 1 minute to Ms. Blackburn.
Thank you, Madam Chairman. I'm only going to take about 30 seconds because there are several individuals that would like to speak on this issue. I want to thank the chairman for bringing forward a discussion draft that will encourage us all to listen to the science and to use some common sense. I am a mother, I am a grandmother, I am an aunt, I am a sister. There is no way I would want to have products in the marketplace that are going to be harmful to children and grandchildren. No way at all. And I think it's important that we listen to the science. I think that it is important that we apply some common sense. I've also listened to a lot of the crafters and the small producers in my area and have had good discussions with them. Also, Mr. Howell, when we get to you, I'm going to want to talk about this database that I think is seriously flawed. And I thank the chairman and yield back.
I thank the gentlelady and recognize the gentleman from Florida, Mr. Stearns, for 1 minute.
Thank you, Madam Chairman. Let me echo what the ranking member at that time, the emeritus chairman, Joe Barton, said. I was a conferee on this. We had lots of recommendations. We, in fact, specifically recommended what the CPSC did in January 2010 when they reported back to Congress, and they identified some of the problems. There was no flexibility, and they recommended solutions. And we had these recommendations under Joe Barton's leadership to provide the CPSC with this kind of flexibility they need to grant exclusions to the lead limits, but they didn't listen. So I think, Madam Chair, what you're doing here is the Lord's work. We need to have the flexibility. And we heard from Commissioner Northrup, who was a former member of Congress. She also brought this out. So I'm pleased to be here and to support you, and I appreciate what you're doing. Thank you.
Thank the gentleman. The last but not least, but the gentleman from North Carolina, the ranking member of our subcommittee, Mr. Butterfield, is now recognized for his 5 minutes.
Let me thank you very much, Chairman Bono Mack, and especially thank you to all of the witnesses who have come forward today to give us your testimony. You know, Madam Chairman, my recollection, and I was simply a rank-and-file member of the subcommittee in the last Congress, but my recollection of this is somewhat different from my good friend from Texas, Mr. Barton. My recollection is that SIPSI followed a long and well-considered road to passage that included many, many hearings and an extensive conference with the Senate. From introduction to enactment, I recall that this legislation at all times remained a bipartisan effort, and I'm surprised to hear today that it was not. The vote tally speaks volumes about the bipartisanship nature of this law. Much of the law was taken word for word from some of Mr. Barton's language that he had authored. The House passed the conference report with a vote of 424 to 1. And while I don't know it for a fact, I suppose Mr. Barton may be the one, but the vote was 424 to 1. And the Senate passed it.
The gentleman, I voted for the bill.
You did
know I
vote.
voted for it.
All right.
For it, yeah,
All right, and the Senate vote was 89-3. Today, however, it's apparent some portions of the law need to be refined. The ranking member of the full committee has acknowledged that, and I do as well. Unfortunately, the discussion draft does not seek to refine the law. Rather, it seeks to undo nearly 2 years of close consultation and careful compromise with members of Congress, industry, many of whom are here today, and consumer groups, and potentially puts consumers and children at risk. The minority was not consulted, to my knowledge, in the preparation of the draft legislation, and I am confident the language would look very different had we been invited to the table and had an opportunity to participate. The draft language would redefine what is considered a children's product to a yet-to-be-determined age, possibly exposing both those who would be classified as children and those who would not to potentially dangerous products. I asked my colleagues about households with multiple children. If a 9-year-old has a toy intended only for ages 9 and older, is it not reasonable to expect that 9-year-old's preschool-age sibling would also want to and will find a way to play with that toy? But perhaps most alarming is rolling back the current lead content limits in favor of risk assessment. This is similar to the model that proved to be inadequate prior to sepsia, but with the twist of creating additional burdens for the Commission. Since the model in the draft will require pre-market risk assessment, CPSC will have to determine for each and every children's product how manufacturers should measure the risk. I am troubled that the draft eliminates independent third-party testing for all children's products, with a very narrow exception for 5 categories. I remind my friends of the millions of toys that were recalled in '07 due not only to high lead levels, but design-related safety defects as well. It was clear that manufacturers of children's products and their suppliers had fallen asleep at the wheel, and their in-house safeguards were inadequate. Finally, and I'm going to yield to a gentlelady from Illinois in just a minute, SIPSIA required the CPSC to create a public product safety information database so that consumers would have a convenient way to report and learn about dangerous products. The draft language marginalizes the efficacy of the database by limiting who can submit information, as well as establishing a drawn-out process by which the submitter, the Commission, and the manufacturer are required to have ongoing contact. The more burdensome it becomes to make a safety complaint, the less likely consumers are to use the database. At this time, I will yield my remaining time, Madam Chairman, to the gentlelady from Illinois.
I thank the gentleman for yielding. To say that I'm concerned about the draft bill would be a vast understatement. Here we are in the Subcommittee on Commerce, Manufacturing, and Trade, and instead of looking at ways that we can create jobs, good jobs for the American people, we're examining a bill to undermine consumer protection, words that used to be part of this subcommittee's title. The draft bill is not a collection of small fixes. It would fundamentally gut key pieces of the CPSIA, including the provisions I authored to ensure that durable infant and toddler products are subject to rigorous testing requirements. I want to read a letter I received from Danny Keyser's parents, which I hope to submit for the record along with 2 other letters from parents who lost their children. Danny's mom wrote, "As parents who have paid the ultimate price for unsafe products, we know you don't want to see more children suffer as our son did. Giving flexibility to the CPSC to enforce safety provisions is one thing, but this wholesale reversal of crucial safety provisions sends us back to a scenario we know leaves children at risk." I yield back the balance of my time.
All right, and the chair inadvertently overlooked the last 30 seconds on our side, and I'd like to recognize the gentleman from Texas, Mr. Olson, for 30 seconds.
I'll be brief. I'm pleased to be here, and I thank the chair for her leadership in bringing forward this important draft legislation to fix the unintended consequences of SIPSIA. As a parent, nothing is more important to me than the safety and health of my children. I think this draft provides us with a balanced way forward that protects my children from harmful products without devastating our country's small businesses. If my children are protected, your children are protected. I thank the chair and look forward to helping you advance a common-sense fix to this law. I yield back.
I thank the gentleman, and now all opening statements are concluded, and we have 3 panels before us today. Each of the witnesses has prepared an opening statement that will be placed in the record. Each of you will have 5 minutes to summarize that statement in your remarks. On our first panel, we have, in reverse order, but we have Robert Howell, Assistant Executive Director of Hazard Identification and Reduction at the U.S. Consumer Product Safety Commission. It's a mouthful. And then Dr. Barbara Beck, a widely respected expert in toxicology and a former EPA Region Chief and Fellow at the Harvard School of Public Health, and Dr. Dana Best, who is presenting testimony on behalf of the American Academy of Pediatrics. Good morning. I'd like to thank you all for coming. You will each be recognized for 5 minutes. To help you keep track of time, the little clock in front of you, when it turns yellow, please recognize that as the 1 minute mark, and if you could start wrapping up and the light turns red, your time is up. Just also ask you remember to turn the microphone on before you begin. And now I'd like to start with Dr. Best for your 5 minutes. Good morning and welcome.
Good morning. Thank you for this opportunity to testify today. I'm a pediatrician and pleased to represent the American Academy of Pediatrics. The AAP is deeply concerned that the subcommittee is considering legislation that would profoundly alter the CPSAA and could reverse the progress towards safer toys and children's products. Today I will focus on 4 areas: the scope of children's products, lead limits in children's products, risk assessment, and the need for third-party testing. First, the scope of children's products should protect children up to age 12. The AAP recommended that the CPSAA cover products for children up to age 12 years based on developmental and pragmatic concerns. With regard to developmental issues, the mouthing behaviors that cause the most concern for exposure to hazards like lead peak in the toddler years and taper off throughout school age, although it is not unusual for school-age children to place toys and other objects in their mouths or to mouth or suck on items like jewelry and pens. For some groups, such as children with developmental delays, mouthing behaviors may persist until adolescence or later. Another concern is that toys are often shared. While most parents work hard to keep toys for older children away from younger children, they may not always be successful. It is therefore important to ensure that toys are as safe as possible for all children in the household. Second, the CPSAA's limits on lead in children's products should not be relaxed. In the judgment of the AAP, there is no scientific basis for establishing a de minimis level for lead in children's products. To date, science has not identified a threshold below which lead ceases to damage a child's brain or body. There is no known safe level of lead. During the development of the CPSAA, the AAP was asked to recommend a limit for lead in children's products. Following a rigorous scientific review, the Academy recommended that lead in children's products be limited to 40 parts per million. The rationale behind this level is explained in my written testimony. The AAP is also concerned that the discussion draft proposes to distinguish between lead exposure due to sucking on an item from lead exposure due to licking an item. From a scientific perspective, there is no basis for making this differentiation. Both actions, defined as mouthing in the pediatric literature, are associated with lead ingestion. The AAP urges Congress to resist calls to set differing standards for lead in children's products based solely on the likelihood of sucking, licking, or swallowing. Given the extreme toxicity of lead, its bioaccumulation, and the irreversible nature of the damage it causes, the concept of setting different levels of lead for various types of toys or children's products is troubling. Third, risk assessment is not an appropriate method for limiting lead exposure in children's products. The draft before the subcommittee appears to shift from measurement of total lead in children's products to risk assessment frameworks. The AAP urges you to leave intact the straightforward, predictable total lead standard in the CPSAA. The fundamental premise of risk assessment is that some degree of risk is acceptable, such as when the benefit of receiving a drug is compared to its side effects. In the case of lead, there is no benefit to exposure, while the harms are numerous and significant, such as decreased IQ. If the CPSAA's standard is altered, Congress would need to determine what level of IQ loss is considered acceptable. In addition, standards should protect not only the average child, but also children at higher risk of lead exposure and its consequences. This is best accomplished using the lead limits currently in the CPSAA. The AAP is deeply concerned that a risk assessment framework would require the CPSC to perform or confirm risk assessment on many different products. It is unclear who would bear the ultimate responsibility for determining risk or what the process would be for reconciling differences when risk assessments differ between the agency and the manufacturer. Finally, third-party testing is necessary to ensure the safety of children's products. The discussion draft proposes significant changes to CPSIA's third-party testing requirements, dramatically reducing the number and types of products subject to independent testing. This would essentially return us to the pre-CPSIA state of affairs in which consumers were expected to guess which toys and children's products were really safe. The AAP would like to make one more comment on another point made in the discussion draft and strongly recommend that non-compliant cribs not be permitted in child care facilities. In conclusion, the AAP urges you to not weaken the CPSIA's protections against lead and other hazards as you consider ways to improve the ability of manufacturers and businesses to comply with this important law. Thank you.
I thank the gentlelady and recognize Dr. Best for 5 minutes. Excuse me, Dr. Beck for 5 minutes. Can you make sure your microphone is on and close to your mouth, please?
Sorry.
Thank you.
Sorry. My name is Barbara Beck. I'm a toxicologist and risk assessor at Gradient, an environmental consulting company, and I've worked on issues of lead exposure, toxicology, and risk for over 20 years, starting from my time at EPA Region 1, where I was involved in development of one of the first cleanup levels for lead in soil that I'm aware of. I've evaluated exposures, toxicology of lead in products, workplace, and in the environment. In its present version, the CPSIA Act has established a concentration limit of 300 parts per million for lead, which will go in August to 100 parts per million unless it's not feasible. This is going to be problematic and is problematic at present, especially for metallic alloys that contain lead, such as tire stem valves. My concern with the present approach is that it doesn't consider the actual exposure, the intake, the absorption, and the impact of lead releases from such products on blood lead levels. Blood lead levels are typically considered the appropriate metric for evaluating exposures to lead. Risk-based approaches have been used to establish limits for lead for decades. It's been used to establish limits for lead in air, water, and soil. Such approaches have been beneficial. Blood lead levels of children in the U.S. have declined by over a factor of 10 over the past 20 years as lead has been removed or reduced from air, from food, and from paint. The proposed changes represent a step in the right direction. Determination of a de minimis level of lead exposure is consistent with what's been conducted with other types of materials such as soil, air, and water. And it also proposes the use of a methodology to identify how much lead is released, what the actual exposure would be from a children's product. This approach is not only consistent with regulatory policy in other settings, but with fundamental principles of toxicology. The dose is what matters. The dose of a chemical, whatever the chemical is, how hazardous it is really critical in determining whether there would be a risk or no risk. I'm not here to propose a specific model or specific de minimis limit, but I do note that the approaches should consider the age of the child, mouthing behavior peaks at age 2 to 3, absorption of lead from the gut peaks around that age, and choosing a value of, say, 7 years old would be protective of younger children. The method that's considered should consider how a child actually interacts with the product, and risk-based methods are available to evaluate mouthing behavior, contact by hand with products, hand to mouth, as well as the potential swallowing of a product and the impact of that contact on blood lead. That can be modeled. My comments that are provided to the committee provide a hypothetical example of how such an analysis could be conducted. It's not meant to propose specific de minimis values or the specifics of an approach, but to demonstrate that there are methods. In my particular example, I demonstrate how a release of 1 microgram of lead from a product per day, every day for a 2 to 3-year-old child would not have a discernible impact on blood lead. Some people may consider that de minimis. In conclusion, I strongly encourage the committee to consider the use of such risk-based approaches in proposing amendments to the CPSIA. Such approaches will allow for health protective risk-based limits that would be sound public health policy as well as sound risk management policy. Thank you.
Thank you, Dr. Beck. Mr. Howell, you recognize for 5 minutes.
Good morning, Chairman Bono Mack, Ranking Member Butterfield, and members of the subcommittee. My name is Robert Howell. I'm the Assistant Executive Director for the Office of Hazard Identification and Reduction at the Consumer Product Safety Commission. I appreciate the opportunity to testify before you this morning regarding certain technical aspects of the discussion draft of legislation that would revise the Consumer Product Safety Improvement Act. The testimony that I will give this morning represents my personal views and has not been reviewed or approved by the Commission and may not necessarily reflect the views of the Commission. In my role at CPSC, I oversee the technical work of the agency within the Office of Hazard Reduction's Directorates for Engineering Sciences, Epidemiology, Economic Analysis, Health Sciences, and Laboratory Sciences. My office is responsible for the collection and analysis of death and injury data associated with consumer products, the evaluation of consumer products for potential safety hazards and regulatory compliance, and the development of technical solutions to produce safety concerns. Prior to joining CPSC in 2006, I served as Vice President of Manufacturing and Operations for a multinational corporation with responsibility for the management of global manufacturing and logistics. On January 15, 2010, the 5 members of the CPSC issued a report to Congress regarding possible improvements to the CPSIA. In suggesting those improvements, the commissioners noted that the recommendations were focused on maintaining the safety and welfare of consumers while minimizing administrative burdens on the agency or significant market disruptions caused by the implementations of specific provisions of the CPSIA. Specifically, the Commission listed the following recommendations for improvement of the statute: that the Commission needs additional flexibility within Section 101 to grant exclusions from the lead content limits in order to address certain products, including those singled out by the conferees. That Congress may, with some limitations, choose to consider granting an exclusion for ordinary children's books and other children's print-based or paper-based printed materials. The Commission believes that a prospective application of the 100 parts per million lead limits would be helpful for our continued implementation of the law, and that the Commission remains committed to working with Congress to explore other ways to address the concerns of low-volume manufacturers with regard to the testing and certification requirements in Section 102 of the CPSIA. From my perspective, the CPSIA has improved the health and safety of consumers, particularly children. In addition, industry has made substantial progress over the past 2.5 years adapting to the requirements of the law. For example, the children's product industry has made progress in reducing the levels of lead since the enactment of the CPSIA. In a recent Commission hearing on the technological feasibility of reducing the lead limits to 100 parts per million, a representative of SGS, a global inspection, verification, testing, and certification company, presented a statistical analysis of lead content testing data with close to 90,000 data points collected primarily from its Shenzhen laboratory that specializes in the testing of children's toys and other children's products. In its analysis, SGS found that 96.3% of metal components tested at or below 100 parts per million. The analysis also determined that just over 97% of glass and ceramic components tested at or below 100 parts per million. Concerning plastic components, SGS found that 99.4% of those components tested at or below 100 parts per million. However, there are certain provisions of the CPSIA, such as the current exceptions to the Section 101 lead limits, that can be improved in such a way as to reduce the burden on the regulated community while maintaining an appropriate level of safety for America's consumers. I personally believe this balance is necessary to ensure efficient and effective implementation of the CPSIA from the perspective of both the regulated community and the regulators. There are several approaches that could allow the CPSC to address the unintended consequences of certain regulatory requirements in the CPSIA. For example, The Commission has heard from a number of members of Congress that they did not intend to cover all-terrain vehicles under the provisions of Section 101. Accordingly, Congress could permit the Commission to exempt certain products like ATVs from the lead limits. This will allow the CPSC to weigh the risk of possible lead exposure to a child riding a youth-sized ATV against the risk to the child from riding a larger and more powerful adult ATV. Assuming that the exceptions would be made on a notice and comment basis, the underlying analysis and support for any exceptions would be public, allowing for transparency and accountability for all stakeholders involved in the process. Finally, allowing the Commission to regulate on a timetable influenced by the seriousness of the actual risk would allow for better priority setting that will permit Commission resources to be put towards the most serious health risk.
If you could please
Madam
sum up
Chairman,
now.
thank you.
Oh, perfect. Thank you. Worked out just well. I want to thank our panel of experts, and now the chair will recognize herself for the first 5 minutes of questioning. And Mr. Howell, the first question to you. How does the CPSC staff go about deciding whether a substance or a product poses a risk to children? And briefly, what factors are important?
As CPSC staff evaluates potential risk to children, it involves several different teams within CPSC. We have a human factors team that will actually age grade the product and determine what particular product characteristics are important in age grading to ensure that the product is targeted to the correct group of children. If, for example, we're evaluating that product with regards to lead, for example, a complete risk assessment would be conducted taking into account not only the intended consumer, but any other children that may be attracted to that particular toy based on characteristics of the toy.
Thank you. Does the Commission have information on the cost of third-party testing? For example, do you know how much it would cost to have a bicycle tested by a third-party laboratory to all the applicable standards?
We have heard from the bicycle industry that the cost to test a $50 bicycle for all the applicable standards would run somewhere in excess of $10,000.
Wow, thank you. And the focus of a lot of our attention, especially on this side of the island, again, Mr. Howell, is the database. I actually think the database is helpful and useful, but I think it has problems, and we should talk about it to a great deal. My thinking is that it is 100% negative, derogatory, and that if the manufacturer can respond, that they are seen as defensive. There must be a way, if you buy anything anywhere on the internet now, Amazon, I mean, even Zappos.com, you know, there are comments on both sides. People can give the good and the bad of a product, yet this database is 100% negative. Can it not be refined so that there is a more accurate depiction of a product? For example, if I complain about something potentially hurting my child, but this is one example out of 10,000, but nobody else would have any way of knowing that. Can't the database be refined to be a more accurate depiction about a product in society?
Chairman Bono Mack, I'm quite certain that either Congress or the Commission could, within CPSIA as written, make modifications, but that is certainly more of a policy matter and is beyond my responsibilities at CPSC.
Well, thank you. I think I made my thoughts pretty clear, though, in my question. So also, to Dr. Best, you state from a scientific perspective that there's no basis for differentiating between a child licking versus sucking on an object. In SIPSIA, however, Congress drew that the very distinction for purposes of phthalate limits. Do you see a reason why this distinction, I always do that on that word, do you see a reason why this distinction makes sense for phthalates but not for lead?
We didn't actually work on the phthalates issue, and so I can do some research and perhaps offer you a response. But again, I'm an expert on lead, not on phthalates.
All right, thank you. And you mentioned also that older children sometimes put ballpoint pens or jewelry in their mouths. You also mentioned that toys may be shared among multiple children in the same household. But aren't there many other items with which older children do not mouth and to which younger children rarely, if ever, have access?
Of course, but but we're talking about the harms to children from lead-containing objects. And so while we can focus on, our focus is on those lead-containing objects that may be dangerous to younger children.
But common sense would say, as a parent, my kids are now 23 and 20, and my stepkids are 8 and 11. Common sense would say to a parent, though, children don't only come in contact with children's products, whether it's a 2-year-old toy, a 10-year-old toy, or an adult, say, electronic component of some sort. Is that not a problem as well? Is it common sense that we're trying to say that from what I understand, a Hannah Montana DVD is under one category and a Miley Cyrus DVD is under another category, and then the DVD player is entirely exempt? So parents ask themselves these questions all the time. It's one of these things. What are they thinking in Washington? Because it makes no sense at all. As a pediatrician, how do you address that?
I'm having trouble understanding the question, but so yes, there are products in the house that are not intended for children and that do not come under the CPSC's purview in this context. And while there are other safety groups that may work with those products, we are focusing on the safety of children's toys here and products intended for children, and that's our focus.
We're out of time. I'll just, to make it a little more clear, that it's common sense sometimes that you can't protect from everything here, and that's the question, is the Commission focused on its highest priority? So I'm sorry, but I need to yield now to Mr. Butterfield for his 5 minutes of questioning.
Thank you, Madam Chairman. Prior to the enactment of this legislation, the Consumer Product Safety Commission assessed the risk posed by children's products containing lead by estimating the amount of lead intake from the product and the subsequent effects of the exposure on blood lead level. For the most part, this was what I call an after-the-fact assessment. That is, the Commission mostly looked at products for exposure to and risk from lead after products had entered the marketplace and been put into the hands of children. The discussion draft seems to create a de minimis exception that makes the total lead content limits in Sepsia more meaningless. Basically, any component part that cannot be swallowed can contain any amount of lead so long as a child isn't expected to ingest more than some amount to be determined amount of lead. So rather than determining the total amount of lead contained in a product, the discussion draft would call on manufacturers to estimate the amount likely to be ingested and takes it as a given that it's okay for kids to take in some amount of lead from their toys. Dr. Best, the de minimis exception in the discussion draft is essentially a return to the approach that the Commission used prior to the legislation. As I read it, any component part of a toy or other children's product, such as a crib, would be allowed to release a de minimis amount of lead, say 6 micrograms per day. Can you please explain what would happen if a child played with more than one toy in one day? Even a child who has one special toy plays with dozens of toys in a day. Could that child be exposed to 6 micrograms per day per toy? I do not read the de minimis standard as requiring the consideration of other exposures to lead in a given day. Can you help me with this?
Well, the Academy is very much against the de minimis standard for many of the points you raised. Lead exposure doesn't come just from one product, one individual product. It comes from the environment. It can be found in our food, in our air, certainly on paint, certainly in the water in Washington, D.C. in the past. And so we are very concerned about the bioaccumulation of lead through all these different sources. Because lead doesn't immediately get passed out through your body, you can actually store it. Some of these stores persist for years, if not decades, and that's one of the things we're very much concerned about.
Thank you. Many of us agree that there are specific products that can't meet the lead content limits and can't be made without lead. We acknowledge that, and that some form of relief should be provided for the narrow universe of products. We agree, some of us, that this relief should be as simple to understand and apply as possible while remaining protective of children's health and safety. So far as I can tell, the proposed de minimis exception in the draft fails in all of these counts. Implementing the de minimis exception will require taking into account very product-specific considerations, and in a good number of instances, it will require applying varying lead requirements for differing parts of the same product. For example, say I manufacture a toy truck that contains plastic and metal, some large enough not to be swallowed and others that can be swallowed. For each plastic component, I would have to ask, is this small enough to be swallowed? If the answer is no, then I would have to ask, how do I expect a child to interact with this component? Is lead likely to be ingested from the interaction? How much lead can I expect to be ingested from the interaction? What age is the child during the interacting? For the metal components, the manufacturer would then have to ask, can I meet the alternative 600 parts per million total lead content standard in the draft? If the answer is no, the manufacturer would have to again run through the analysis as I described. Can it be swallowed, so forth and so on. Mr. Howell, let me ask you this, yes or no, sir, and I'm going to be out of time momentarily. Would the Commission have to develop multiple methodologies given that children interact differently with different products?
Yes.
Would requiring the Commission to develop multiple methodologies to account for the different ways children interact with different products and parts require substantial investment of the Commission's limited resources?
No.
In your experience, sir, do retailers and manufacturers prefer clear lines for compliance over estimating the likelihood that their product might behave in a certain way?
Many do.
Under current law, sir, enforcement is simply the product meets the standard or it doesn't meet the standard. Under the draft that we have in front of us, the Commission's enforcement seems to be more complicated. For each product at the border where there might be a problem, the Commission will have to do complicated testing. Couldn't this slow down products and have them retain longer at some of our ports?
Yes.
All right. Thank you very much. My time is out.
All right, the Chair recognizes the Vice Chair of the Subcommittee, Ms. Blackburn, for 5 minutes.
Thank you, Chairman, and thank you to our witnesses. Mr. Howell, I would like to start with you, if I may, please. As I mentioned in my opening statement, the database. As we held our initial hearing on this issue, we are very much aware that the database is incomplete, it has problems. The Chairman mentioned some of the problems that are there with how information is recorded. And I want to know two things from you, if you would please, sir. Number one, would we be better off to take that thing down until the problems are worked out? And number two, what needs to be done to correct the problems that are around the database? Very quickly, please. I've got other questions.
Ms. Blackburn, but because the problems that you cite are not clearly defined, I'm going to respond to your question clearly in a very broad way. You know, certainly the decision whether to keep the database up or down becomes a policy decision. It is not one that my technical staff necessarily are the appropriate ones to make. You know, the challenges of implementing anything that's new certainly require the attention of staff in order to get it right. Many of the things that we see in the database, regardless of the nature of the reports of harm, would require resources to get a handle on the appropriate way to respond.
Okay, and I will help you with that definition. The prior hearing that we had, we heard from the commissioners that if there's a complaint against, say, Graco cribs, then all Graco cribs are, you know, you don't define between that. So I would ask you to submit to us in writing with a little bit more detail what you think needs to be done, because I think we need to take the thing down and bring it offline, work out the kinks, and then bring it back so that it is understandable to consumers so they know exactly what the product is. And so there is a method for them to evaluate what actually is the problem, and then if they do or do not want to purchase that product. At this point right now, people can just rail against a brand and not necessarily a specific product or a part. And there is that problem of definition within that use. I want to come to Dr. Beck. Mr. Vitrano, who's going to testify on the next panel, submitted testimony to us, and we thank you all for submitting your testimony in advance. And in there, he talks about the lead intake from children's interaction with ATVs is less than the intake from drinking a glass of water. And I would like to know, in your opinion, do you agree with that? Do you find that to be an accurate statement, and a little bit of definition around that? And see if what I'm looking at is if the metal parts on an ATV contain higher lead than are permitted by the EPA for drinking water standards. I'm sure you can understand our confusion with that issue.
Yes, his statement is correct. It's based on analysis that we did in which we had wipe samples, because the question is, how does a child interact, say, with a valve stem? We had samples of wipes that were rubbed the valve stem, and that was to mimic a child touching a valve stem when they fill their
Okay,
tire.
so Dr. Beck, it would be true that a child gets more lead content in drinking a glass of water than from playing with an ATV.
They would get more lead from what is commonly found in drinking water but is permissible under EPA than they would get from contacting their hands with a valve stem on an ATV or from touching the hand.
Okay, now let me ask you this. Do you find this with other products? Have you found this same association in other products that you have tested, maybe with the wipe test?
We have also done wipe tests on scooters, and we had similar results, that what came off in a wipe was relatively small, less than what a child might typically get from drinking water.
Okay, thank you very much. I appreciate that, and I will go ahead and yield back.
Thank the gentlelady. The chair recognizes Ms. Schakowsky for 5 minutes.
Thank you, Madam Chairman. Mr. Howell, in your testimony, you note that an independent testing lab, SGS, has found that almost 90% of toys tested by it recently comply with the 100 parts per million lead limit. While I realize this is data from only one entity, it seems to provide at least some evidence that the children's product marketplace has largely adapted already to the 100 parts per million limit. Would you say that's true?
Yes, I would. I would also add to that, though, that it may also indicate that we are rapidly approaching a point of diminishing returns, in that the effort to achieve the final reduction in lead may be much more costly than the incremental cost of getting to where we are today.
Certain members of industry have been very critical of fixed parts per million limits for lead in children's products and have advocated a move back, as we heard from Dr. Beck today, to risk-based standard. However, the American Society of Testing and Materials, ASTM's F963 toy standard, which has been drafted through a consensus process and is now a mandatory rule under the CPSIA, contains fixed parts per minute limits for certain toxic metals in surface coatings of toys like cadmium, is it antimony, and barium. And in those areas, well, so I'm asking, why not lead? If they could go to a ppm for other things, why not lead? And let me pose the same question to Dr. Best, but Dr. Howe?
You know, certainly you can regulate lead either on a fixed content limit or on the extractable amount. You know, that becomes basically, you know, not only a policy choice, but a choice of economics and ease of test, if you will, that would facilitate compliance.
So would you say that? Would you say that it's easier to administer for many companies and for the Commission to go on a parts per million basis?
Certainly there are advantages to testing by content in the fact that it is at times much faster. It certainly doesn't generate the level of hazardous waste than wet chemistry does. But at the same time, I believe Another way to look at the problem perhaps would be a balance between both the parts per million content at some prescribed level and then a risk assessment approach at levels above that to deal with perhaps products such as ATVs and bicycles, where the exposure is perhaps much less of a concern than you might have in something that's mouthable or swallowable.
Thank you. Dr. Best, I wonder if you would comment on these issues.
One of the big differentiations between the CPSIA and the ATSM or MS, whatever, their levels is that the ATSM's levels are soluble lead. And we are concerned not only about the surface coating, but as a product wears, the surface coating may be worn off, and so then you're getting deep into the content of the whatever product we're talking about. And again, the swallowing question comes into play.
Right, but my question is, if the toy manufacturers could go to a parts per million for these other things, why not with lead? Well, we believe that they can go to a total lead content level and achieve that reasonably. And as some of these data have shown, many manufacturers do. Okay. One other question on lead content. You had mentioned that children with disabilities sometimes continue mouthing, well past a little kid, and yet products designated as I'm looking what it's called, special products for the disabled are not in the category that would require mandatory third-party testing for almost all children's products. Do you think that's a mistake? I can't say I know all of the definitions of special products for the disabled. Certainly, I wonder if some of them are more adaptive products, such as adaptive listening devices and adaptive hearing devices. So they're not toys. And so we have been very focused on the toys, and so that's where all of our evidence has been based. Thank you.
All right. Chair recognizes Mr. Barton for 5 minutes.
Thank you. Mr. Howell, my recollection is that in the last Congress and in the hearing in this Congress that the commissioners who testified that the current law doesn't give them the flexibility that they need to implement the law. Is my recollection correct?
I recall the same thing.
You recall the same thing. So that's a yes.
That's a yes.
Okay. Dr. Best, what's wrong with giving the CPSC some flexibility to implement the law?
They have, and it is my understanding, that they already have some flexibility to...
That's not their understanding.
Well...
I mean, they've testified at least twice that they need more flexibility. So let's stipulate that they don't have flexibility. Why then would it not be prudent for Congress to give them some flexibility?
Well, the stipulation I would have to look at, but the concern we have is that children's health is not something that should be negotiated based on manufacturers' profit.
Well, nobody is saying that the stipulation should be based on profit. That's a fairly obnoxious comment to make in reply to my question.
When we do a risk-based
report of harm, manufacturers can file a claim of material inaccuracy.
How many have done that so far?
I believe there's been less than 10% have filed claims for material inaccuracy. They can also file claims for confidentiality, which is extremely rare at this point in time. And they are certainly free to file a comment without necessarily filing a claim of inaccuracy or confidentiality.
How many have said, not me, not my stuff?
The vast majority of the material inaccuracy claims tend to be just that nature. It's not my product.
And are those still online, readily accessible to the public? So you send it to the manufacturer, they say it's not my stuff. Are you then putting it online?
No, if they claim that it's not their product, that's a valid claim of material inaccuracy, and until such time as that's resolved and the product is clearly identified, it does not get posted.
Ms. Best, you talked to, thank you, Mr. Alt. Ms. Best, you talked about, she's not here. Let me ask you one more question, Mr. Powell. How many items from the punch list that Commissioner Tenenbaum gave me on the database have you all been able to work through since she was here? That is, what's still left to fix?
I'm not familiar with that punch list. I will certainly respond to that in writing.
Thank you. Madam Chairman, I yield back the balance of my time.
I thank the gentleman and recognize Mr. Butterfield to explain the absence of the witness.
Thank you, Madam Chairman. You would notice that Dr. Best is absent this afternoon. I want the record to show that she had prior obligations this afternoon and had to leave. I'm told that she is seeing patients today and had scheduled those appointments with the understanding that we would convene this morning at 9 a.m. instead of 10 a.m. But please be assured that she will be available to answer any questions that any of the members may have. Thank you.
I thank the gentleman and would remind the committee that we did delay the starting point of today's hearing to accommodate the Democrats, and it's unfortunate that the witness had to leave, but remind members too he can submit further questions to her in writing later. And at that point, we'll be happy to recognize Mr. Harper for 5 minutes.
Thank you, Madam Chair. Mr. Howell and Dr. Beck, thank you for being here today. I'm sure you can come up with a list of a dozen things you'd rather be doing, or maybe 100 things, but we welcome you, your attendance, and appreciate what you're sharing with us. And Mr. Howell, just a couple of questions on some issues involving this. And I know that when we're talking about the common toy box theory, applying, of course, to toys, it seems like there are a lot of other products that it really makes no sense at all. For example, infants and toddlers are not going to have access to motorized products like ATVs, or at least we hope they're not, or to those type. Are these things? What's the situation on, say, ATVs and other things like that when it comes to these regs?
One would certainly not expect that small children would have frequent access with those type of outdoor products, certainly.
Okay. When we talk about, say, electronics, you know, the Commission set much higher lead limits for certain metal alloys. When the Commission granted a stay of the lead content limits for ATVs and bicycles, it set temporary limits at the same or very low or similar levels, I mean. Why does the CPSC consider them to be safe, or at least safe enough for now? What's the rationale for that?
When the stay of enforcement was issued, it was simply a stay from the testing and certification requirements. There was not a stay of the requirement to conform to the law as written. So the limits that are established are the limits that were prescribed in law.
Got you. Now, I'll ask if the Commission is aware of any deaths in fixed side cribs in daycares.
Would you repeat that, please?
Sure. Yes, sir. Is the Commission aware of any deaths involving fixed side cribs in daycares?
I am not aware of any, but I will certainly take that question back and have our epidemiologist do a data pull.
You know, in your testimony, Mr. Howell, you've suggested the Commission be allowed to regulate it on a timetable influenced by the seriousness of the actual risk to allow for better priority setting. Do you have specific suggestions that you can share on how you can do this, or how we can do this?
I believe any organization that has finite resources needs to ensure that they are allocating those resources to the highest priorities. You know, certainly there are various ways to rank those within the Commission. One might suggest that frequency and severity at risk populations are all criteria that would help identify higher priority projects versus those that might fall lower on the list. And it's really all about managing finite resources in a way that provides the greatest return on those efforts.
Okay. Dr. Beck, There will be, I believe, Mr. Vitrano, who will testify on the next panel, submitted testimony that says you estimated the lead intake from children's interaction with ATVs is less than the intake from drinking a glass of water. And I ask if that's true or any info on that statement.
Yes, we did an analysis in which we used wipe tests from ATVs, so we had actual data, and we compared how much children would get from that scenario versus what a child might drink in a typical glass of drinking water, which may contain small amounts of lead. So that's a correct conclusion from our analysis.
And when was that analysis done? How recently?
It was, I believe, either 2008 or 2009.
Right, but wouldn't it be true, though, that the ATVs, the metal parts of the ATVs, contain much higher lead than is permitted by EPA drinking water standards?
It's a little bit apples and oranges because
Sure.
the drinking water standard is based on what's in the water.
Right.
That's a very low concentration in the water. And then if you were to say, what does that mean in terms of, you could compare it to ppms in a valve, and of course that would be much, much higher. But it's a little bit of an apples and oranges comparison.
But based on that analysis, you're concerned about ATVs as it concerns infants and toddlers. You would not be overly concerned with that at all, would you?
No, because it's really not a plausible scenario.
Sure. Okay. I yield back.
Thank the gentleman, and recognize Dr. Cassidy for 5 minutes.
I've really enjoyed this panel. All of you have attempted to be very fact-based and reference-based, so let me just first compliment you, and my compliments to Dr. Best, who's no longer here. I'd like to, first you, Mr. Howell. Now, clearly it's common sense that an ATV, a kid's not going to chew on an ATV, and probably not on the stem of a bicycle. On the other hand, I can understand if there was some other product that the varnish wore off that the child could gnaw down to and actually have some lead exposure. So I guess my question to you is are we able to come up with a definition that which is absurd that the kid would ever chew on is moved over here, and that which it is plausible is moved over there? Is that something within the Commission's ability to accomplish?
Certainly in the Commission's traditional risk-based evaluation of consumer products, that would be an evaluation that would be conducted. How a child interacts with the product is important in determining the level of risk that child may be subjected to from that certain product. In the case of ATVs, we would find it less likely the child would swallow or mouth an ATV. Certainly you would expect that there could be some migration of lead from contact with the hand on an ATV.
Now, I gather from Dr. Best, and I'm sorry she's not here because I just wanted to explore this, because all three of you know so much more about this issue than I. That's why you're the panel members, I'm not. That there was some dissatisfaction with the risk-based assessment. So now, I'm sure there's many aspects of risk-based assessments, but was one of the areas that folks were unhappy with, did that include your ability to differentiate lead paint peeling off a wall from an ATV, one is a great risk, one is a minimal risk for lead exposure?
You know, I have certainly heard the arguments against risk-based, but am not fully aware of all the underlying rationale behind that criticism.
So it sounds like you feel like risk-based is a practical thing for the Commission to implement.
The Commission has been using a risk-based approach for decades now.
Now, you mentioned in response to Mr. Harper, the last line of your testimony, to effectively prioritizing Commission resources towards those of the most serious health risk. Now, I've learned in life that if you attempt to monitor everything, you end up monitoring nothing. But on the other hand, if you monitor a few things, you often can monitor them well. Now, and I've also learned that there's oftentimes, 99.9% risk with this subset of activities and 0.1% with this subset. Is that so clearly broken out in lead exposure? Can you say, listen, this is really high-risk stuff. We need to focus our resources even more so than now, if we were so allowed, as opposed to this, which is incredibly low risk. We're kind of killing our time over here.
Certainly the agency is extremely concerned with those lead-bearing items that can be swallowed. Acute exposure to lead is certainly a very serious thing. One would expect that the risk decreases as you move from swallowing to mouthing, from mouthing to touching. And the management of that risk at that point then becomes a decision on how the child interacts with the product and what you...
So you again, by risk-based, would make some differentiation between high and low risk, and it all be upon how the child interacts and the relative amount, et cetera, et cetera.
Yes, that is a basis of...
Now, the other thing that occurs to me is that we've heard last time from a previous panel about the craft makers. And, you know, somebody in Oregon who makes these nice little airplanes and apparently needs a third, I shouldn't laugh, but, you know, would make probably 100 planes a year, sells them out of their shop, and now has to get a third-party assessment as to the lead content of the paint. Now, in your risk assessment, do you also say, listen, if it's below a certain production value or quantity per year, this actually falls, I mean, the ability of something that's produced on the scale of 100 a year is, as one example, is really unlikely to have a significant impact. Do you have any such sort of evaluation like that?
Our evaluations from a risk approach is a product evaluation, and the consideration of the number of the volume of the product produced is not relevant to the assessment of the risk that that particular product may present to the consumer who's using that product.
Yeah, it wouldn't be for the particular consumer, but it would be for the epidemiology of it in terms of a population issue, correct?
Absolutely, and when it comes to prioritizing the agency's work, that's where the frequency severity factors come into play.
So you do incorporate the population aspect to it. Okay, well, thank you. Ms. Beck, I'm sorry, no questions for you. It's just mine were more oriented to Mr. Howell. Thank you.
Chair recognizes Mr. Kinzinger for 5 minutes.
All right, let's see if I can get this to work here. Well, maybe. Well, how are you doing today? Hopefully well. I don't need to take a lot of time because I think you guys have been very good at answering the questions. I appreciate your time. I appreciate the chairwoman for organizing the hearing. You know, one of my concerns when we get to government involvement in areas is something that I affectionately refer to, and as many others do, is the law of unintended consequences. You know, it's obviously when somebody does something that looks great on paper and then in actuality has a completely different effect. So, Mr. Howell, my question, thinking in terms of the law of unintended consequences to you, do you agree with the past acting chairman Nord's statement of April 3rd, 2009, that the application of the lead content mandates of this act may have actually the perverse effect of actually endangering children by forcing youth-sized vehicles off of the market, and in a result, actually children riding vehicles that are bigger or, in essence, too big for them, adult-sized ATVs, if you will?
I agree with that statement.
Okay, so you do agree with that. I'd like to, Madam Chairwoman, I'd like to ask unanimous consent to insert 2 documents into the record.
Without objection.
The first is a statement from Acting Chairman Nancy Nord of the CSPC from April 2009 requesting exclusions from the lead content limits of the Consumer Protection Safety Improvement Act of 2008. The other is a letter from Edward Moreland, Senior Vice President of the American Motorcyclists Association, to Chairwoman Bono Mack and Ranking Member Butterfield regarding the discussion draft. The next question I have, common sense seems to support the notion that youth model OHVs should not be subjected to the lead content provisions of this act. Would one of the solutions to this conundrum be an outright categorical exemption, like the one provided in it's H.R. 412? It's called the Kids Just Want to Ride Act. It's one I'm a co-sponsor on.
As a policy decision, that certainly would be an option.
Okay. Well, that's, like I said, those are basically my 2 big questions I had. You all have done a great job here in front of us today. I appreciate your time, and I would yield back my time.
I thank the gentleman, and at that point, I'm happy to thank our panelists for staying and for your expert testimony. We appreciate everything you've had to offer today, and hopefully we'll craft some great legislation. So thank you for your time, and we will spend a quick 30 seconds or a minute seating the new panel and get started right away. Thank you again.
Back.
All right, thank you. Our second panel is comprised of 4 witnesses. Welcome, and thank you for staying with us this morning. Our first witness, again, but not in the order of recognition, but to introduce Erica Jones. She's a partner at Mayer Brown, here representing the Bicycle Product Suppliers Association. Welcome. Our second witness is Paul Vitrano, General Counsel for the Motorcycle Industry Council. Also testifying today is Sheila Millar, a partner at Keller & Heckman, LLP. And our fourth witness on this panel is Caroline Cox, Research Director for the Center for Environmental Health. Welcome to each of you. You all know the drill now, the 5 minutes and the clocks and how they work. So if you could just pay attention to those, we appreciate it. We will have some floor votes again eventually, so if we can move it along, that would be terrific. So now we're going to begin with our first witness and recognize Ms. Cox for 5 minutes.
Thank you very much for the opportunity to testify today. My message is that CPSIA, as written, has been an enormous success, and I'm really privileged today to be able to provide research data to document that success. You heard earlier that health professionals agree that there's no safe level of exposure to lead for children. So I'm discouraged to see the proposed revisions in the CPSIA that would weaken a law that has worked so well to protect American children from unnecessary lead. For the last 15 years, my organization, the Center for Environmental Health, has worked to protect children and families from harmful chemical exposures. Our experience before and after passage of the CPSIA demonstrates that the law has been highly successful. Prior to adoption of the law, we found high lead levels in dozens of children's products sold to millions of American families by major retailers. At that time, there was no federal law to protect children from lead, so we relied on California state law. Since the lead limits under CPSIA went into effect, our experience shows a dramatic change in the marketplace for children's products. In the last year and a half, we purchased over 1,200 children's products from major national retailers and screened them for lead. These were stuffed animals, toys, games, lunchboxes, backpacks, jewelry, toy sporting equipment, lots of other things. As far as we know, it's the largest independent monitoring of compliance with CPSIA to date. Out of these 1,200 products, we found only 46 that did not comply with the CPSIA lead standards based on tests by a CPSIA certified lab. In other words, more than 96% were in compliance. And because we intentionally purchased products that were likely to have lead problems, we believe overall compliance is even higher. This data contrasts with what we found in 2007 and 2008. Our results show that over the 4-year interval, the prevalence of lead hazards in children's products was reduced by a factor of about 3. Given the immense size of the U.S. market for children's products, this is a major accomplishment. We do understand that CPSIA requirements can be a hardship for small business, and we'd support amendments to help with that. We believe that the CPSIA has been effective because one, the lead standards are comprehensive. They cover virtually all children's products and all accessible parts of those products. And that's created a huge market for compliant materials and components. The standards are straightforward, and because they're based on a total content standard, testing is accessible, consistent, and affordable. Lead content standards are the only kind of standards that allow materials and components to be tested upstream in the supply chain. When you have exposure-based standards or risk-based standards, the testing can only be done on finished products after it's already made. And the third point I would like to make is that the lead standards apply to a really meaningful definition of children up to age 12. Because lead is a cumulative and persistent toxicant, it's particularly important to maintain this requirement. Protect children as they move into their teenage years and girls move into childbearing years. I wanted to just give a quick visual demonstration of the success of the CPSIA. Here's Curious George from 2007. His face contains lead at a level 20 times the current CPSIA standard. Don't kiss this George, and I think most kids probably wanted to. Here's the current post-CPSIA George. George is lead-free and sold at the same price. And I think this really shows how successful the law has been. We respectfully recommend that this committee support the public health success that CPSIA has been. Crucial support includes the lead content standards as well as the definition of a child as 12 years old and younger. Thank you so much.
Thank you, Ms. Cox. Ms. Millar?
Thank you, Chairman Bono Mack and Ranking Member Butterfield, members of the subcommittee. I appreciate the invitation to appear here today. As a longtime consumer protection attorney, and I think all the members of the panel here and everybody in this room share the same view, we need and want a strong and effective CPSC that has both the authority and the resources necessary to adopt and enforce national consumer products safety standards. Where we differ is that some of us favor revisions to CPSC's arbitrary one-size-fits-all limits that apply irrespective of the type of product, material, age of the user, or actual risk of exposure, its illusory or non-existent exemption scheme, its retroactive effect, and burdensome testing requirements, which have cost money and jobs. Based on my experience with many different federal agencies, if I've learned one thing over the years, it's that sound public policy should be based on facts and science and risk. So I want to focus on a few key points from my written testimony. First, the lead and substrate limits were derived from the unfounded assumption that presence equals risk. It doesn't. And I think Dr. Beck illustrated that point carefully this morning. The CPSC's own research has demonstrated that materials that are high in lead may sometimes yield less migratable lead or about the same amount of migratable lead as products that comply with 600 or 300 parts per million. Exposure is the key to risk, and so we do believe that revisions that are more targeted to exposure, keying off of proven things that the CPSC has done for years, makes a lot of sense. In terms of the lead exemption process, the proposal here offers a good step forward, but remains unnecessarily complex. In addition, the limited exemption scheme is coupled with a general provision that gives the CPSC new authority to adopt 600 ppm limits on older children's or even adult products. Because I support a risk-based approach, I favor neither the current exemption process as drafted nor giving CPSC general authority to simply adopt a 600 ppm limit on any product irrespective of risk. In contrast, the phthalates provision offers an elegantly simple view that could be applied more generally. It tracks the CPSIA exemption for inaccessible component parts, but gives the Commission authority to adopt health-based exemptions, exemptions from the prohibition that are not necessary to protect children's health. Why not adopt a consistent, science-based exemption process for both lead and phthalates, predicated on the simple basic rule that the government should not be in the business of banning safe products? I do want to spend a couple minutes talking about testing. Let me be clear. Testing has an important role in compliance. And as Mr. Howell referenced this morning, there may be ways to look at how to dovetail testing regimes with supplier assurances, self-certifications, and other proven techniques that help confirm safety. Let's also be clear that the prospect of $15 million penalties offer very powerful incentives to comply, to say nothing of the prospect that your products will simply be rejected by your customers. From the standpoint of total content testing, I differ with Ms. Cox in that we have seen over and over again that total content lead tests are not so uniform as you might expect. There is considerable variability, and the absence of any definitive interlaboratory variability factor is a key problem, particularly as levels drop lower and lower. So when we look at these differences in terms of interlaboratory variability, a material which may have residual lead content, let's say a plated piece of metal, where you're building on a piece of tin coupled with a nickel plating, a copper plating, a silver plating. At the end of the day, the addition of those added metals, each of which could have residually low total content, could put you above 100 ppm. And I think we've seen the need for exemptions to perhaps look at a broader array of material to address that naturally occurring problem. I would also caution against assuming that component testing is the solution to all ills with certification testing here. I represent many raw materials suppliers of plastics, chemicals, and other materials, and they're simply not willing to subject themselves to the jurisdiction of the CPSC to provide component test certifications in the rigid scheme required by CPSIA. I strongly support a national safety net for consumers. I also strongly support reducing unnecessary burdens on the regulated community by restoring to CPSC its authority to make sound risk-based decisions. Thank you again for the invitation, and I look forward to responding to any questions.
Thank you very much. Mr. Vitrano, 5 minutes.
Chair Bono Mack, Ranking Member Butterfield, and distinguished members of the subcommittee, thank you for the opportunity to testify. I am Paul Vitrano of the Motorcycle Industry Council, which represents nearly 300 manufacturers of motorcycles and ATVs, aftermarket companies, and allied trades. We appreciate the subcommittee's efforts to address the unintended consequence of the CPSIA, which has effectively banned the sale of youth ATVs, motorcycles, and snowmobiles. The Act has actually created unsafe situations for young riders by reducing the unavailability of appropriately sized, speed-restricted youth models. As you noted during the last hearing, Chair Bono Mack, the CPSC has made the judgment that the risk of lead exposure to children is outweighed by the risk that children face if youth ATVs are not available. The Act also has cost manufacturing and dealership jobs. We urge Congress to fix this unintended ban and appreciate the subcommittee has offered an initial draft reform bill. Within the framework of the draft bill, the only way to fix the ban on youth vehicles with certainty and without imposing further needless costs and burdens on our industry and its customers is to amend the range of children's products, at least for these vehicles, to age 6 and under. Alternatively, we ask you to consider adding a categorical exemption to the bill. There already is widespread support for this approach. Representative Rayburn has authored the Kids Just Want to Ride Act, H.R. 412, which currently has 61 bipartisan co-sponsors. And just last week, Senators Klobuchar and Tester offered a categorical exemption as an amendment to the small business bill currently before the Senate. ATVs and motorcycles do not present any lead-related health risk to young riders, and Congress has made it clear that it never intended the lead content restrictions for toys to apply to these vehicles. We ask that you keep in mind the following points as you work to provide young riders in our industry with much-needed relief. First, the lead content in metal parts of ATVs and motorcycles poses no risk to kids. As Dr. Barbara Beck testified earlier this morning, the estimated lead intake from kids touching metal parts is less than the lead intake from drinking a glass of water. Second, everyone agrees that the key to youth safety in ATVs and motorcycles is ensuring they ride the right-sized vehicles. By reducing the availability of these vehicles, the CPSIA has created, in the CPSC's own words, a, quote, more serious and immediate risk of injury or death, close quote, than any risk from lead exposure. Third, in 2009, MIC estimated that a complete ban on youth model vehicles would result in about $1 billion in lost economic value in the retail marketplace every year. Fourth, motorcycles and ATVs are motor-powered machines, not toys or other articles kids wear or play with. So the extent and nature of the children's interaction with our vehicles is materially different. As you know, kids do not mouth tailpipes or swallow battery terminals. Young riders typically only touch a few parts of the vehicles, like handlebars and clutch levers, and often with gloved hands. Finally, ATVs and dirt bikes are stored outside the house, usually in garages, sheds, or barns, and thus are much less likely than household items to be touched by young children. In addition to being remotely located, the vehicles have keys, and use is controlled and supervised by parents. There are two common-sense ways to fix this problem once and for all, and without imposing further unnecessary testing and certification costs and burdens on our industry and customers. We urge you to exclude these youth vehicles from the lead content provisions by lowering the age range to primarily intended age 6 and under, or adding a categorical exemption. We also support the recommended changes to the CPSIA database provisions. One of our members recently received a report of harm where a rider who had been drinking prior to riding rode off a cliff at night in the dark. Nothing in the report indicated any problem with the ATV, but because the CPSA database on its face only accepts reports of, quote, unsafe, close quote, products, the inclusion of this report will result in the ATV implicitly being classified as an unsafe product. Unless Congress acts, the database will become a repository of inaccurate information that defames manufacturers and misleads customers. We believe the modest changes proposed in the draft legislation would result in a more useful database with accurate and relevant information for consumers. Thank you. I'm happy to answer any questions.
Thank you, Mr. Petrano. Ms. Jones, you're recognized for your 5 minutes.
Good afternoon, and thank you for inviting me to be with you this afternoon. I'm Erica Jones, and I am counsel to the Bicycle Products Suppliers Association, which represents most of the manufacturers and importers of children's bicycles and adult bicycles offered for sale in the United States. The bicycle industry has taken very seriously the expectations of Congress when the CPSIA was enacted. The bicycle industry has made substantial progress toward reducing lead in children's bicycle products or making the lead inaccessible to children, and appreciated the stay of enforcement that was enacted by the Commission and used that time productively to make these design changes and material substitutions in their products. Nevertheless, the industry is facing another brink of uncertainty as later this year a new standard of 100 parts per million looms on the horizon and presents a number of feasibility and practicability challenges for the industry. The industry presented data to the Commission in February of this year and again last month in written comments, providing data from testing of a bicycle that was spec'd by its manufacturer to be below 100 parts per million, because retailers are beginning to demand that level of achievement. And despite this effort to reach that goal, over 38 of the over 100 parts that were tested by the laboratory exceeded 100 parts per million. And that's attributable to the variability that is present, inherent, and we think at this point can no longer be worked out of the system. These were metal parts. The bicycle industry has solved the issue with respect to plastic and other non-metallic parts, but continues to have a problem with those components on bicycles that are made from metal alloys. A witness at the CPSC regulatory hearing last month, who was retained by the bicycle industry and who runs a CPSC certified lab, testified that he has, in his experience, seen a shrinkage in the number of children's bicycle models that are offered for sale and the number of manufacturers willing to engage in this sector, which means a loss of choice for consumers. And this, we believe, is attributed to the cost of testing for the over 100 parts of a bicycle that are accessible and therefore have to be tested. Bicycles provide safe, affordable, and environmentally friendly transportation. They provide children with an enjoyable means of outdoor exercise, which we think is far more important for the health of children than protecting them from the theoretical risks from touching metal bicycle components with their hands. If lead testing costs make children's bicycles too expensive for average families to afford, or if affordable used bicycles are difficult to obtain, the health of America's children could be affected far more than from the presence of lead in a tire valve stem that they may touch only on occasion. I'd like to address a comment made by the previous panel by Dr. Best, who made a comment that there is no benefit to lead and therefore it should be inherently unnecessary. We disagree with that. Lead, in the quantities that we see it in metal alloys that are used in bicycle, provide a tremendous benefit. They provide corrosion resistance. Lead alloys provide strength and durability that is needed for appropriate performance of a bicycle. and it would not be socially useful or desirable to produce a bicycle that may meet a lead-free standard but which falls apart or which cannot be operated in an outdoor environment where it's intended to be used. The industry applauds your subcommittee for convening this hearing today. We believe there is a need to reform the CPSIA to reverse these unintended consequences and eliminate the unnecessary regulatory requirements that are driving up the costs of children's bicycles, making them less available, and we urge prompt action on sensible reforms of the CPSIA. Thank you.
Thank you, Ms. Jones. You get the record for coming in 45 seconds short. So I'm going to recognize myself for the first 5 minutes of questioning and direct my question to you. You made reference several times in your written testimony to the August timeframe. What happens in August that this timeframe is of such concern that we need to do something about it in this amendment that we're looking at?
On August 11th of this year, the lead standard for substrate will drop to 100 parts per million, and under the current interpretation of the statute, that will have immediate effect at the retail level, meaning it will really be retroactively applied to products that are on the retail shelves that are being built right now as we speak. And that has a devastating effect on product planning. And as I testified a few minutes ago, and as we've submitted data to the CPSC, the 100 parts per million standard is technically not feasible right now for the bicycle industry to meet.
Thank you. And you also state that, except in the rarest of circumstances, new government standards should apply prospectively to products that are manufactured after the effective date of the standard. Can you give us examples of circumstances in which new standards have been applied immediately and or retroactively, and how do those examples differ from the instance we have before us?
Well, the best example is the one we were just discussing of the 100 parts per million, which will apply immediately on August 11, not to products built after that date, but to products on retail shelves as of that date. The same process applied when the 300 parts per million standard took effect last year, or in 2009, excuse me, and it had the same effect and disruptive effect at the retail level. This is not the norm for product regulation in other government agencies, where normally, even at the CPSC as well, normally manufacturers are given lead time to plan for the new regulation, to redesign their products, to absorb the costs in a more orderly fashion, and to work out their inventory so that products sold after the effective date reach retail shelves in a compliant fashion. That's the proper, orderly way to regulate products for safety improvement, not to disrupt the market with these very abrupt changes that do not permit that kind of orderly transition.
Thank you. Ms. Cox?
Could I make a brief comment there?
No, I'd like to move on. I've got limited time, and I do have a question for you, though. And you do mention that the FDA's warning about lunchboxes containing lead, claiming that FDA interpreted CPSC's data differently than CPSC itself. How many lunchbox recalls did FDA order after it reviewed CPSC's data?
This happened a long time ago, but my recollection is there were not recalls, but just a warning letter sent to lunchbox manufacturers telling them to fix the problem.
I guess you mentioned this in your testimony, that your discussion of lunchboxes suggests that FDA would disapprove of a risk-based lead standard and insist on a total lead content standard, but in fact they don't have any total content standard for lead, do they?
Yeah. I actually think the example of the lunchboxes shows that one of the big advantages of the total content standard, it provides a clear, consistent number which manufacturers, retailers, regulators, everybody knows what the threshold is. I mean, one of the issues with the lunchboxes was that it occurred pre-CPSIA, and so different agencies interpreted the results of the risk-based testing in different ways. And what we have now with CPSIA is a clear standard, and lunchboxes all across the country. I mean, I've tested a lot of them over the last couple of years, and they're great.
All right,
they comply with the standards.
Thank you. Ms. Millar, why isn't a total lead standard as health protective as an exposure-based standard?
The risk to a child is based on, or to any consumer is based on actual handling and use. one of the assumptions that is incorrect that's underlying CPSIA is the notion that 100% of lead and substrate will migrate out of the product. That's actually not true, and the CPSC's own data demonstrates that actual migration rates are generally very low, even in worst-case 24-hour acid ingestion test conditions. That's why we think that total content, and I think Mr. Howell expressed it this morning, can be useful as a benchmark screen, but absolute limits that ban products that actually don't result in exposure of the sort that Mr. Vetrano and Ms. Jones talked about this morning do serve to essentially ban products that are objectively safe because they don't result in significant harmful exposure to the consumer who's handling the product.
Thank you. Mr. Butterfield, you're recognized for 5 minutes.
Thank you very much. Let me go to you, if I can, Ms. Cox. In your testimony, you state that exposure assessment testing is a subjective process, open to interpretation and manipulation. Is that a fair characterization of your statement, that it's subjective as opposed to
It's
objective?
definitely subjective, yeah.
All right. And the gentlelady on the first panel, Dr. Beck, testified and supports the risk assessment. Seems to provide support for your view as well. Her written testimony that she submitted indicates that assessing risk is highly contextual and hinges on a number of factors. Dr. Beck testified that you would want to know a lot of different things. You would want to know what the product is, how frequently a child interacts with the product, the duration of the interaction. Will the child likely bite or suck on the product? Will the child touch the component? How large an area the child will touch, and so forth and so on. That's about 7 separate pieces of information that Dr. Beck identified. And I can add a couple more. How old is the child, and in what stage of development is that particular child? What's the nutritional status of the child? Does the child have certain genetic traits that will lead to great absorption and so forth? It seems to me that perhaps the only person who could know all of these things and come up with that type of risk assessment will be someone who is superhuman. Let me start with one simple question. Is it correct that with a lead content limit, a manufacturer or a retailer only has to know the answer to one simple question? How much total lead is in the component?
Yes, that's correct. And just to add, to reinforce what I said earlier, that allows the manufacturer or anyone in the supply chain to specify to their suppliers the type of material that they need.
Dr. Beck also in her testimony asserted that a standard based on soluble lead is generally preferable to a standard based on total lead. And as I understand it, total lead is a measure of how much lead is in a component, period. This is the measure required by the legislation. Solubility, on the other hand, refers to the amount of lead released from a component under certain specified conditions. Is it correct, Ms. Cox, that the conditions for measuring solubility are not consistent? That is, they could choose to vary the time, temperature, and the solution that is used, whether to agitate the solution and so on. Would you elaborate on that, please? Yes.
I think I could just say that I have actually heard people in the laboratory and testing industry say that if something complicated like a solubility test or other exposure-based testing was required, that there actually wouldn't be lab capacity enough to be able to do these tests because they are so much more complicated and time-consuming than a simple test for lead content.
Well, will changing even one of these conditions affect the amount of lead that will be released during the test?
I think, yeah, I'm not a lab specialist, but that is my understanding, yes.
My next question is, I guess I have time to do it. Let me try this. In your testimony, Ms. Cox, you point out that a total lead content limit allows companies to specify materials that meet the standards when contracting with suppliers. If I understand you correctly, a manufacturer can tell his or her metal supplier, I want to buy metal from you, but only metal that contains no more than 300 parts per million, and a supplier would be able to easily fill that order as specified. Could you respond?
Correct.
Yeah.
And the exposure-based testing you can't do until the product is completed, so that would happen at the very end of the manufacturing process, whereas with the total content, you can specify the content of all the materials and components that are used in the product, so it allows you to do it sort of pre-manufacture rather than having to potentially reject a product, a product after it's already made.
Right. All right, Madam Chairman, I yield back.
Thank you, Mr. Butterfield. And now I would like to recognize Ms. Blackburn for her 5 minutes.
Thank you so much, and thank you all for your patience today. Ms. Cox, I enjoyed listening to your testimony, and especially that you used Curious George. I've got a 3-year-old and a 2-year-old grandchild, and that's one of their favorites. Let me ask you something. Do you find more lead in products that we import or products that are domestically manufactured?
I think probably everybody here is aware that virtually all the products on the shelves of major national retailers are products that are not made in this country. So when we find products that exceed CPSIA limits, it's not surprising that that's also true.
Okay. I just have, in listening to your testimony and the testimony of others, it's been kind of curious. And Mr. Vitrano and Ms. Jones, I'll ask you, with motorcycles and bicycles, do you all find more lead in those that we import or those that are domestically produced?
All the major manufacturers of ATVs actually produce many of the models in the U.S. itself.
Okay.
Some models are made by those companies from outside the U.S., and of course,
well, maybe that they're domestically produced is one of the reasons we have less lead in a wipe test than in a glass of water. Ms. Jones, bicycles?
Most children's bicycles are not made in this country any longer.
Okay, and so you don't see that as being pertinent to what you all do?
We do not see that as being pertinent.
Okay, that's fine. You know, I've wondered if maybe since we've driven manufacturing out of this country is one of the reasons we're here having this hearing today and talking about the amount of metals that are there and some of the environmental litigation that has been brought forward and has driven manufacturing away from our shores. Maybe that's one of the reasons that we are here, and I know, Ms. Cox, that the Center for Environmental Health uses litigation quite frequently under California's Prop 65 warning requirements. And I know that you all do some work, and wanted to ask you, do you all get a bounty for identifying violations under Prop 65 labeling laws?
Proposition 65, for those of you who don't know, was a ballot initiative in California in 1986.
Yes, but you identify violations under this,
right,
or violators. So do you all get a bounty?
The statute as passed by the voters provides for, if the statute is violated, there are civil penalties that are paid to the state.
Yeah, I've got some of them in front of me.
Who identify the violation is entitled to 25% of those civil penalties.
Okay, so I've got an exhibit in front of me that identifies some of these. So if one type of fashion accessory listed above is checked, it would be $45,000 in that identification. So you all would get 25% of that if you identified those.
Yeah, 25% of the civil penalties.
Okay. All righty, so 25 of the 45,000. So, okay, is this a funding revenue stream for your organization?
My organization has a diverse source of revenue. Like most nonprofit organizations, we receive grants from foundations. We also have a strong, committed group of individual supporters who support us financially, and then we do get some money from our litigation as well.
Is that with the Lexington Law Group? Is that under a consent decree?
Could you repeat the question? Sorry.
I said, is that with the Lexington Law Group, your litigation? Okay, let's move on. So then you get some money that comes to you through identifying these violations. And most of the product, I guess, that you are looking at is things that are imported and they're on the shelves of major retailers. Is that correct? And how many lawsuits have you partnered with the Lexington Law Group?
Let's see, there were a lot of questions there.
Yeah, let me help you out with this. My time's nearly out. What I would like to know, and you can submit in writing, I would like to know what percentage of your funding relates to litigation. I would like to know how many lawsuits you have partnered with the Lexington Law Group, and I would like to know how much money you have made, what your revenue stream is from Prop 65 lawsuits and violations since the passage of SIPSIA. And with that, Madam Chairman, I yield back the balance of my time.
Yeah, I think it probably would be best for me to provide that information in writing since it's a lot of numbers.
Yes, ma'am, I was asking for it in writing.
Yeah, I'd be happy to do that.
For the record.
Thank you. The chair is happy to recognize Mr. Pompeo for 5 minutes.
Thank you, Madam Chairman. Following up on Ms. Blackburn, would you submit all of the sources of funding for your organization when you put that in writing to us? Not only that you get for Prop 65, but other sources for funding for the center, the CEH?
Yeah, I'd be happy to. And just to clarify, the work that I talked about in my testimony, monitoring for CPSIA compliance, that money came from the California Department of Justice, California Attorney General.
So governmentally funded. Is that right?
Sorry?
Government funding from the state of California.
It went through a private foundation, but the source of the money was the Attorney General's office.
Thank you. Ms. Moore, it's fascinating to me. I'm new here. This is all very fascinating. You, on the other hand, you get paid by your clients. And you're here today trying to avoid them paying you by reducing the regulatory burden. I find that fascinating to see the charitable effort you're making here today. Yeah, no, I truly meant it that way. I meant it as a compliment. Ms. Jones, you said that you have a problem with metal alloys in the bicycle industry.
Yes, sir.
Why do you use metal? Just why don't you stop using it?
Metal alloys add a great deal of important value to bicycles. They help the bicycle be corrosion resistant. They help them be strong and durable. And we really couldn't make bicycles without them.
So there's no substitute.
Well, no, that's not true. There are substitutes, for example, carbon fiber. Some very high-end racing bikes for adults are made of carbon fiber, but they'd be way too expensive.
But I'm not going to buy that for my son.
You are not going to buy that. It'll be too expensive.
Yeah, my son might like it, but I'm not going to buy it.
There's no affordable, practical substitute.
Thank you. That's what I figured. We were talking before about these different tests. Mr. Butterfield, Ms. Cox asked you about some different tests, and you said, boy, the testing would just be really hard. He was describing this testing would be very difficult, soluble, non-soluble. It would be really hard and inconsistent. Is that right? And so you then said, yeah, that'd be hard, so let's just take a simpler test that probably doesn't really accomplish what we're trying to do. So it's a proxy at best. The perfect testing would be hard and difficult, so what everybody defaults to is this simple test that really doesn't get to the true risk of exposure to a consumer of a product. Did I understand your response correctly?
I would prefer to phrase it as
I'm sure you would. But I'd prefer if you not rephrase it, but simply answer my question.
The goal of CPSIA was to remove a toxic metal from children's products, and and there'd been a long history prior to CPSIA of risk-based approaches not being successful, and the lead content standard has been very successful at changing the marketplace and getting lead out of these products.
I have no doubt, and banning lots of things would make them successful too. We can always create a test that's over-inclusive and solve a problem, but as you can see from Ms. Jones's comment earlier, we create another one. My son doesn't get to exercise on his bicycle. Ms. Moore, do you have a view on the testing that Mr. Butterfield asked Ms. Cox about?
Yes. As I said earlier, and I think Mr. Howell alluded to this as well this morning in his testimony, the ability to use total content as screening is an important tool. There's no question about it. And I think it is true that people do try to target where they can, meeting a certain limit. It does help in the supply chain. It is not true that total lead tests are always uniform and never varied. We see a lot of different variability in total content tests. And I think the problem becomes that when you establish an absolute ban, what we've seen for bikes, for ATVs, for certain pearlized buttons, for example, have agents in them that are metallic. You can have violations of total content limits where objectively applying standard accepted procedures that the CPSC uses, whether it's a wipe test, a saline test to mimic mouthing, which is a 6-hour test procedure, they have an established procedure, or their updated 24-hour acid exposure test, you can establish whether or not that product is going to pose a risk. And so the manufacturers are going to always target to some objective limit where they can. The problem is that you're going to ban them where they exceed it, where there's not a risk.
Makes sense. I've got one more question, just 20 seconds. Ms. Millar, your clients are Mr. Vetrano or Ms. Jones. Have any of you had any experience responding to a CPS database complaint at this point? They've only been a month. Have any of you had any experience responding?
Yes.
How'd it go?
We still have a couple in process, but it's certainly something that people pay attention to. They take it seriously. They, in no case, however, has a client to date had a materially inaccurate incident report submitted to them.
But they've had to spend a bunch of money talking to you. Yeah. Thank you. I yield back my time.
I thank the gentleman and recognize the distinguished Chairman Emeritus, Mr. Dingell, for 5 minutes.
Madam Chairman, thank you. The questions are to all witnesses, and I would very much appreciate it if they be answered yes or no. First of all, beginning with Ms. Cox, are you aware of a uniform, reasonable methodology in use by manufacturers of children's products to find what is the amount of lead in a product? Yes or no?
Yes.
Ma'am, Ms. Miller?
Yes.
And you, sir?
Yes.
Ma'am?
Yes.
Okay. Now, is it possible the ambiguity of the term reasonable methodology could lead to a wide variance in test results across manufacturers of similar products? Yes or no? Ms. Cox?
Yes.
Ms. Miller?
No.
Sir?
I don't know.
Ma'am?
No, we're not seeing that.
The next question. If it would lead to a variance, do you believe that this could pose a risk to the health of the children who use such products? Yes or no? In other words,
I'm
if
able to
there's a
answer that
variance,
question.
is that variance going to put the children at risk? Well,
certainly we need consistent
why don't you
testing.
reflect
Is
on
that?
it? Ms. Miller?
I don't see the variability, so my answer is no.
And you, sir?
It would depend on the variability.
Ma'am?
And we're not seeing the variability.
Ms. Cox, you want to take another shot at it? All right, we'll go to the next set of questions because time is very limited here. We have the term accredited third-party conformity assessment bodies. I assume that this includes both domestic and international bodies that would do this kind of testing. Am I correct? Yes or no, Ms. Cox?
Yes.
Ms. Miller?
Yes.
Yes.
Sir, if you please. Ma'am?
Yes.
All right. Now, if so, how many such assessment bodies are there worldwide? I don't expect you to know, but give me a shot in the dark, the best count you can give. How many do you think there are? Ms. Cox?
I don't know.
Ms. Miller?
A couple of hundred, I believe.
Sir?
For youth model ATVs, there currently is one.
Ma'am?
For bicycles, there are only 2 in the U.S. and about a half dozen outside of the U.S.
Thank you, my friends. Does the Commission have the resources with which to verify the testing capacity of all of these third-party conformity assessment bodies? Yes or no? Ms. Cox?
I don't know.
Ms. Miller?
I don't know.
Sir?
I don't know.
Ma'am?
I don't know.
Now, Is it your understanding of the draft legislation that the Commission would have to accredit all third-party conformity assessment bodies, yes or no? In other words, would they have discretion under the legislation to decide who they would accredit and how and why they would accredit or not accredit, yes or no?
I don't know.
Ma'am?
I don't know.
Sir?
I don't know.
Ma'am?
I don't know.
All right. Now, in summary, do you believe that the effect of these requirements would be that the Commission would seldom, if ever, require third-party testing of children's products? Yes or no? Ms. Cox?
I don't know.
Ma'am?
No.
Sir?
No.
Ma'am?
No.
Now, here are some questions about the database which are troubling us, and everybody, I think, is troubled. Is it your understanding that CPSIA requires all information submitted to the Consumer Complaint Database to be published online within 10 days of its receipt, regardless of the accuracy of the information? Yes or no? Ms. Cox?
I don't know.
Ms. Miller?
Yes.
Yes.
Generally, yes.
Thank you. Now, should a manufacturer be given the opportunity to contest the accuracy of a consumer complaint before it is published? Yes or no? Ms. Cox, please. What's your opinion? Just your best judgment on the matter, please.
These questions are outside my expertise.
Then I'll not press you on it, ma'am. Ms. Miller?
Yes.
Mr. Vitrand?
Yes.
Ms. Jones?
Yes.
All right, now if a manufacturer is allowed to dispute the accuracy of the information in a consumer's complaint, how should the dispute be resolved and by whom? If you please. Ms. Cox?
I don't know.
Ms. Miller?
I think the CPSC should resolve the inaccuracy before posting the complaint to the database.
Mr. Vitrand?
CPSC should resolve it before posting.
Ms. Jones?
CPSC should resolve before posting.
And the gentleman's time has expired.
I thank you, Madam Chairman. I have one more great question. Could I ask unanimous consent to ask it, please?
Yes, without objection.
The draft legislation amends CPSIA to permit only persons directly harmed by a consumer product, their family, their legal representative, or another person authorized on their behalf to submit a complaint to the database. Previously, CPSIA permitted anyone to submit complaints about a consumer product. Do you believe that the draft legislation's narrowing of eligibility to submit the complaints is necessary? Yes or no?
Not necessary.
Okay. Ms. Miller?
Necessary.
Mr. Vitrand?
Yes, it's necessary.
Ms. Jones?
Yes, it's necessary.
Madam Chairman, you have been most courteous. May I have an additional unanimous consent request? I have a splendid statement that I have labored long and hard on.
I have nothing but fondness and admiration for the distinguished chairman, but we still have another member and another panel to go and votes on the floor. So I will.
I'm not delaying you, Madam.
Madam Chair,
Statement I'd like to put in the record.
whenever the Chairman Emeritus talks like that, he has a pleasant surprise for us.
Well,
I would ask
Debating
unanimous
yours-
consent to yield to the Chairman Emeritus.
Thank you very much. No, it's just a statement that I want to put in the record, Madam.
Of course, without
And
objection.
I do thank my good friend for his kindness to me. Thank you, Madam Chairman.
Thank you. And remind the room, I'm new at this chairmanship, so I appreciate the kindness of the distinguished Chairman Emeritus, but we'll recognize Dr. Cassidy for 5 minutes.
I don't know. I'm sorry, I was out when y'all were making the testimony, so I don't know if anyone can address what I'm about to ask. As I look at the epidemiology of lead poisoning, it seems to be not generally distributed, but it seems to be in certain populations. Those which are recent immigrants, for example, appear to have a disproportionate amount of lead toxicity. And in fact, I was looking at something from a hospital in Los Angeles that found, even within the Hispanic community there, there was 3 zip codes, which were particularly impoverished zip codes, in which there was even more. Now, assuming that toys are generally distributed, but that the people who have problems with lead toxicity are concentrated in certain areas, it suggests to me that the culprit for those children who have increased lead, it may be geographic or related to how recently they came from another country without standards, than it is almost anything else. I toss that out, not knowing if anyone can answer that or if these are just musings. Anybody want to take a crack at that?
I'll take a crack at it. Exposure to old lead-based paint in homes is the primary source of lead exposure to children, and that's been the case for several decades. Current statistics are about 70% of elevated blood lead levels in children are caused by exposure to paint. The other 30% are not.
No, wait, I'm sorry. So let me, just so I understand. So if you have a blood level of 100, just to pick a number, does that mean that 70% of that 100 is related to paint exposure and 30% to another environmental factor? Or does it mean that 70% of the children that have elevated lead levels have it due to paint?
70% of the children with elevated blood lead levels, they're able to trace back that exposure to paint.
So the 30%, is that those for whom no point source can be identified, or those for whom another point source is identified?
In general, when there's a child with an elevated blood lead level, there's a huge effort to identify the source. So the number of unidentified ones is small.
And so, again, as I look at this concentration among recent immigrants, it suggests to me that recent immigrant status is a separate factor. I did my medical residency in Los Angeles, and we used to see all these diseases from other countries in Los Angeles. Very odd diseases that we wouldn't see in Washington, D.C., for example, even though this is also a place of immigrants. I guess, to what degree do we know that what is the impact of immigrant status? Is there exposure to lead that's occurring south of the border that we're importing?
I'm not aware of any statistics about immigrant status and lead exposure. I do know that because the deteriorating paint is a factor, living in older housing or housing that's not well maintained.
The 30% of folks for whom paint is not a factor, what percent of those, and I should know this, but I've been trying to track it down, and I apologize, what percent of those have a point source identified? And what are those point sources?
The point sources tend to be lead in soil, lead in water, and then lead in various kinds of consumer products.
What, for example?
Examples of consumer products?
With lead that have been identified as a risk for the children.
Jewelry, toys, there's some lead-containing makeup that's been a problem. There's lead-containing foodware that's been a problem.
I assume that some of this, though, must be older stuff. I mean, I can remember playing with lead when I was a kid. Obviously, my mother didn't care for me.
Yeah.
So I'm assuming that much of what is now available, with or without these regulations, that lead is gone. Is that a fair statement? I'm looking at all of y'all now because I can only imagine that my pencil that I used to chew on in 3rd grade probably had lead in it.
The regulation of lead over the last 40 years has been, one of the country's greatest public health successes. So removing lead from paint, removing lead from gasoline, and then removing lead from other consumer products has had a dramatic reduction in the number of children with elevated blood lead levels. The goal of CDC was to get that level to 0 by 2010. It hasn't quite happened, but
and if it's true that immigrants are the cause of a lot of this, it'll never happen. I just say that because our tuberculosis problem will never go to 0 as long as we have people immigrating from Mexico, because it's just endemic there. I'm just trying to understand to what degree can we attribute products, toys, for this as opposed to everything else. Thank you for your time. Thank you.
Thank the gentleman, and that concludes the panel. And I'd like to thank Ms. Cox and Ms. Millard, Mr. Vetrano, and Ms. Jones for your time and testimony today, and I'm sure we'll be working together in the future on refining this legislation.
Madam Chairman, may I be recognized before the panel leaves?
Yes.
Earlier, Ms. Blackburn requested Ms. Cox if she would furnish financial information for her nonprofit organization, and at first I had a little heartburn about that, but after I thought about it, it's an appropriate request. It goes to her credibility as a witness today. As a former judge, I guess I should know that. But I was wondering if it would be appropriate to ask the other three witnesses if they would similarly furnish the sources of their revenue for their organizations that they represent.
Well,
Yes.
I'll remind the gentleman that you can submit any question you would like to any witness and that you have 10 days to do so, and that remind the gentleman also that members of Congress are allowed to ask any question that they would like of any witness. And again, remind you that you have that prerogative to do that in writing to the witnesses. And with that, again, if the gentleman will yield back. I thank the panelists again and would call forth the third panel. If we can get seated, we're going to have votes shortly on the floor, so we would love to get started and see how much progress we can make. So a short break, and then we'll roll into the third panel.
Rachel, where do you want to sit? I don't think we get to choose. Yes, he said just sit wherever you want.
Do you? Yeah. Hi. Thank you very much.
You can sit next to me if you want.
It's your choice. So is this first or last? Are you gonna, do you know how you?
Thank you. That was a quick transition. Thank you, staff. So now the third panel. I'd like to thank you all very much for being here. We have the final four witnesses. First up, we have Frederick Locker of Locker, Greenberg, and Brainin, PC. Our next witness is Charles Samuels of Mintz, Levin, Cohn, Ferris, Glovsky, and Popeo, PC. Also testifying will be Dan Marshall, Vice President of the Handmade Toy Alliance. And our fourth panelist today is Rachel Weintraub, Director of Product Safety and Senior Counsel for the Consumer Federation of America. Welcome, everybody. You know the drill, 5 minutes. You know where the lights are. So we're going to begin, Mr. Samuels, with your 5 minutes. Thank you and welcome.
Dear Chair Bono Mack and members of the subcommittee, thank you for the opportunity to testify. I have the privilege of serving as General Counsel of the Association of Home Appliance Manufacturers, as well as represent companies on product safety matters. I support a fully resourced, focused, and effective commission with the tools to protect Americans from unsafe products. I supported the revamping of the federal product safety laws, and I respect the hardworking and dedicated officials at the commission. Unfortunately, parts of the law are overreaching, over-prescriptive, and distort the agency's mission to the detriment of consumers and industry. The discussion draft makes great strides towards remedying the imbalances and deficiencies in the current law without doing violence to the core public policies. I will focus on the database provision. Technology should be used to disseminate good and easily accessible information to consumers about product safety. It makes no sense, however, for so much of the resources of the Commission to be invested in this effort unless it provides useful and accurate information to the extent feasible. We cannot expect perfection, but we now have a database that can be manipulated for purposes other than that intended. Vague, useless, and incorrect information can be placed online. This not only harms manufacturers, retailers, and importers, but harms consumers.
Consumers to question the effectiveness of our nation's safety net.
The CPSIA has restored consumer confidence by requiring children's products to be tested for safety, by banning lead in certain phthalates in toys, and by creating a publicly accessible consumer complaint database and authorizing necessary resources to CPSC. The consumer community has stated previously that any changes made to the CPSIA must not weaken product safety standards and must not weaken public health protections. The current discussion draft fails this litmus test, unfortunately. This discussion draft is not narrowly tailored, but rather carves gaping loopholes in the consumer protections created by the CPSIA. It covers fewer children's products, undermines the lead and phthalate standards, substantially weakens the third-party testing requirements, and makes the consumer complaint database vastly less useful for consumers. I will highlight some of the most critical provisions of the discussion draft in my testimony. We oppose an effort to weaken the scope of the protections of the CPSIA. The discussion draft implies that only those products for children of some younger age, we presume, should be afforded protections by the CPSIA. Congress embraced the belief that there is a shared toy box, which we know reflects the reality of what is true in many homes across this country. School-aged children are at risk from lead exposure and from hazards posed by powerful magnets in toys, for example. If those toys are not required to meet any lead limit or meet the standard for magnetic toys, the potential for harm is large. Further, the voluntary standard for toys, ASTM F963, covers toys intended for children under age 14 years of age. The third-party testing provision of the CPSIA will be eliminated almost entirely by the discussion draft. Third-party testing is necessary to confirm compliance with safety rules and prevents hazards before they enter the marketplace. While the discussion draft preserves third-party testing for lead and paint, full-size cribs, non-full-size cribs, pacifiers, small parts, and children's metal jewelry, the fact that all infant durable products other than cribs will not be subject to third-party testing is untenable, and there's even ambiguity about the crib standard. The provision makes it very difficult for CPSC to require third-party testing for other products. The rulemakings required in this section require a cost analysis while ignoring the benefits of lives saved, injuries avoided, or healthcare costs reduced as a result of the testing requirement, and no time frame is established for these rulemakings. This section lists products that can never be required to undergo third-party testing, but fails to define them. While we understand that a narrowly targeted exemption for third-party testing provisions may be the only solution for small batch manufacturers, the lack of definition and an alternative testing mechanism to ensure safety makes it impossible to determine the appropriateness of this relief. The discussion draft puts babies at risk in child care facilities by allowing fixed-side cribs to remain in use if there is required supervision. Solely removing the drop-side cribs misses numerous other hazards that the new crib standard addresses, such as hardware failures, material integrity problems, mattress support failures, slat hazards, and corner posts. This provision drastically weakens the consumer protections of the CPSIA and will keep babies in known unsafe cribs. The Consumer Complaint Database will give consumers access to life-saving information and will help CPSC to more nimbly identify and act upon safety hazards. CPSC's rule is responsive to the public interest need for disclosure and protective of a manufacturer's effort to protect their brand and confidential business information. The database includes more checks on the information and more opportunities for a manufacturer to comment than other similar government agency databases. The discussion draft tips the balance that the database rule has achieved by limiting who can report to the database, unnecessarily increasing the types of information consumers must report before their complaint can be considered for posting, requires consumers to unwittingly engage in a dialogue with the manufacturer about the reported harm rather than simply reporting the incident to the CPSC, stays the reporting of information until final decisions about the sufficiency and accuracy of the information are made, and will substantially increase the time it will take for information to be posted publicly. This will discourage reporting by consumers to the database and decrease the utility of this important consumer protection. I thank you for your consideration, and I'm happy to take questions.
Thank you very much. All right, the chair recognizes herself for 5 minutes for the first round of questions. And I'd like to ask Mr. Marshall, please, would you be willing to register with the Commission in order to qualify for the small batch exemption to the third-party testing requirements?
I think that would be a fair trade-off so that the CPSC would know who the small batch manufacturers are, and it would be consistent with how the FDA approaches food labeling laws. So yes.
Thank you. And you mentioned the other laws that have provisions to accommodate the different circumstances of small batch manufacturers. Can you say more about the approaches that you believe are the best?
Well, the issue with third-party testing is cost, so I think it makes sense to create exemptions based on the number of units produced per year. That seems like the most logical way to us to get at the cost versus the output of a particular manufacturer.
Thank you. Ms. Weintraub, first of all, your testimony, you and I have not read the legislation at all in the same way, but you testified that the subsia became law as a result of a period of record numbers of recalls of hazardous products that injured, sickened, or killed children. What I remember most are the lead and paint recalls, and no one here will ever argue that lead and paint restrictions should ever be loosened. However, the most significant problems with this bill relate to lead and substrate. Putting aside metal jewelry, again, restrictions for which we do not intend to loosen, were there any children injured, sickened, or killed by lead and substrate? And if so, how many? And can you provide verified statistics of those injuries?
I can't provide verified statistics of those injuries because many of those injuries are silent. They could cause, and likely have caused, but we just don't know, neurological impairments, decreases in IQ.
Yeah, I'm sorry, you're saying they're all speculative injuries that you...
No, I wouldn't say that
but
they're
silent.
speculative, but they're very difficult to document.
All right. And you also, again, contrary, you and I read the legislation entirely differently. Contrary to what you said in your testimony, the discussion draft does not deprive consumers of third-party testing. It gives the Commission authority to decide what should be third-party tested. You know, what I've heard from the commissioners is that they need a little bit more common sense, the ability to apply common sense. You completely disagree with that notion, and what I see in the legislation and what you see are entirely different?
Well, I'm not entirely sure what you see, but what I see is a system where there's a list of products that are subject to third-party testing, a list of products that can never be subject to third-party testing, and then a very rigorous rulemaking without any timelines that's required in order for other products to be third-tested.
You're saying that there are products that can never be tested?
My understanding was that there is a list in this discussion draft that includes...
Have you seen the discussion draft?
Yes, I have seen it.
Okay, but your understanding, I'm sorry, you confused me right there. You said your understanding is that...
Well, you're disagreeing with my interpretation, so...
well, and you disagreed with mine, so I...
Well, the way that I read the discussion draft is that there are a list of products which are undefined, products for children with disability, one-of-a-kind products, works of art, and small products manufactured by small batch manufacturers that would never be subject to...
Well, nothing is excluded from testing, and the Commission can decide to impose the testing. But just moving on a little bit to Mr. Samuels, you state that the Commission has made some unfortunate interpretations in implementing the database. What interpretations are you referring to, and are they corrected by this legislation?
Thank you very much. Two very troublesome interpretations is their unnecessary, in fact, I think really improper increase of the number of parties that can make reports of harm, so that it includes trial lawyers, it includes consumer groups that may not be direct representatives of someone that's harmed. It's totally improper, and your draft limits it to those people who are really harmed and their representatives, which is what the database is supposed to be all about. Second thing is a very unfortunate interpretation that even if a manufacturer has claimed a material inaccuracy in a report, that it isn't even their product, that if the 20-day clock runs out, they're going to post it anyways, even if they have failed to resolve it. That's unfair and unnecessary, and your draft does a very good job on dealing with that.
Thank you. I just want to finish my last 9 seconds by saying that I believe the database has room for improvement, and we can do all of these things, but I also want to go on the record that I support the database. I think there's some consternation from the other side that I don't. But I think it is very flawed, and we should make sure that it serves both the public and make sure that we continue to make Made in America matter again. So with that, I'm happy to recognize Mr. Butterfield for his 5 minutes.
Thank you, Madam Chairman. Ms. Weintraub, are you, well, you're probably well aware that the existing law that we passed a couple of years ago sets clear lines on total lead content that becomes increasingly stringent over time. The purpose of decreasing the amount of lead allowed in children's products over time was to gradually get these products closer to a total lead level that would not result in at least one form of neurological damage, and that is the loss of IQ. Some manufacturers, however, have been complaining ever since the law went into effect, many of whom were at the table when the law was being written, that there is no way they can make their products without certain components that exceed the limits, and that those components don't put children's health at risk. The discussion draft that we have seen, and you've acknowledged that you have seen, attempts to give these manufacturers relief from the lead content limits. However, it does so in a very broad and far-reaching way that not only lets those who claim they need lead for their products to function properly, to exceed the limits, but lets anyone who wants to continue using lead to do so as long as they are willing to play a game of risk with children's health. The de minimis ingestion base standard in the draft is available for any component part so long as it isn't a small part, and there's no consideration of whether lead needs to be in that particular component. My question to you is, to the extent there is bipartisan sentiment that Congress should grant manufacturers some form of relief from the lead content limits, do you agree or disagree that any such exception must, as a fundamental matter, consider whether that product needs to have lead in it to function properly?
I agree.
Let me now move to, let me skip over a couple of questions. I'll stay with you, if you will. Tucked away at the very end of the Republican discussion draft is a one-sentence section regarding the effective date of the amendments in the draft. Although that section is at the very end and only one sentence long, what this section says is actually quite important. As I understand it from my staff, what this sentence says is that anyone who is currently in compliance with any part of CPSIA gets a free pass. Would you agree or disagree with that, and would you elaborate for me, please?
I do agree. I think that provision that you're referencing is a truly retroactive provision of this law. I think the term retroactivity as applies to other lead standards, I think, is legally not accurate. But in this case, I think this is true retroactivity. The one sentence actually states that this draft will go back to the time that the CPSIA was passed in August of 2008.
Okay. Where's the database question? Do we have one on the database? Which one is that? Okay. I want to get to the database in the few seconds that I have left, and this is a rather long question. Would you, this is going to be too lengthy for me to complete in the time allotted, but would you speak to the database that we rolled out a few weeks ago and tell us your conclusions on it?
Sure. The consumer complaint database is a very important consumer protection. It's so important because consumers have been in the dark about product safety. There's many incidents that we know about, and obviously others that we couldn't possibly know, where consumers were just completely in the dark, that manufacturers had information about a safety problem with the product, CPSC may or may not have known, and consumers continued to use the product. They were in the dark, they were under a veil of ignorance, and weren't able to make the right choices for their families because they just didn't know about incidents that sometimes were pervasive and affected many, many people. So what the database seeks to do is equal this playing field a little bit. It still requires CPSC to go to manufacturers outside of the database before they can release information about particular products. But it requires a very specific number of fields of information that really narrow the information so that information has to be very targeted to the type of harm, a description of the product, and really provide useful information to consumers. And unlike other government databases, it provides a place where manufacturers can comment simultaneously. So when a consumer, if you go on the database today, you will see a consumer filed a comment, and then in the same page, the manufacturer files a comment, which is significant.
Thank you. I yield back.
Thank the gentleman, and the chair now recognizes Mr. Olson for 5 minutes.
I thank the chair, and I thank the witnesses for your knowledge, for your patience, and your persistence. And my first question is going to be for you, Ms. Weintraub. Which is more dangerous? A product of 10,000 parts per million lead that does not leach enough lead to result in a measurable increase in a child's blood lead level, or a product that contains 100 parts per million lead that leaches enough lead to result in a measurable increase in a child's blood level?
I think it depends on a number of scenarios, so I'm not sure. I could get back to you.
Okay, so you can't tell me between 10,000 parts per million or 100 parts per million?
I think there's many factors that go into that sort of analysis, so I'd like to review the information and get back to you if I could.
Okay, thank you. I'd appreciate that. Is there a mechanism in SIPSIA to permit these safe products to be sold to children under age 12?
I'm sorry, can you repeat that?
I can, yes, ma'am. Is there a mechanism to aid SIPSIA to permit these safe products to be sold for children under age 12? Safe lead products.
Well, I'm not sure that I agree with the underlying assumption of the question, but products intended for children 12 and under have to meet the current lead standards as well as the other mandatory standards that are relevant to those products.
Okay, thank you for that answer. A couple more questions. You testified that Congress took over a year in a deliberative process to consider the implications of this law. Unfortunately, as much as we would like to think we are not immune to error. We are not omniscient. I would bet the vast majority, if not all, the members of Congress had no idea we would be essentially banning bicycles, jungle gyms, and golf equipment in a time of child obesity crisis. Ban science equipment like microscopes and organic geology sets, again, in a time when our students are falling behind in the sciences. Or ban musical instruments at a time when our students are also falling behind in the arts. Did you know this law would ban those products?
I think what's important to note is that lead is not necessary to be in products. And if it is in fact necessary, I think that should be part of any analysis that would give flexibility for any type of exemption, because the important thing to focus on from the consumer perspective is that when consumers are purchasing a product for their child, a toy, they don't expect that they will be exposing them to risk. And especially when it comes to lead, it's impossible for a consumer to identify whether there's lead in that product. So the consumer is really relying on the manufacturer and also relying upon Congress and the CPSC to make choices that will protect consumers.
And we're doing that, ma'am, with all due respect. And one final question. You testified that SIPSIA became law as a result of, quote unquote, a period of record numbers of recalls of hazardous products that injured, sickened, or killed children. What I remember most are the lead in paint recalls, and no one here will argue that lead in paint restrictions should be loosened. No one. However, the most significant problems with this bill relate to lead in substrate. Putting aside metal jewelry, again, restrictions for which we do not intend to loosen. Were there any children injured, sickened, or killed by lead in substrate? How many, and can you provide verified statistics of those injuries?
I believe I answered a similar question previously, and I'll answer the same information, that unfortunately I am sure that there were injuries, there were harms to public health, but it's very difficult to document because these harms and these injuries occur as neurological impacts to effects of behavior and decreases in IQ. So it's very hard to document. But to say that there's been no harms from lead and substrate, I think is not accurate.
I appreciate those answers. Again, I'd submit to you that it's important we know those answers before we take action. We should be able to document it. And I yield back my time.
Would the gentleman yield, actually, for your final minute? I'd like to ask a follow-up question, if I might, to Mr. Locker. and take the final minute. So you state the regulations have departed from sensible risk-based decision-making at the Commission, and the law does not grant them the ability to make common sense decisions. There's those words, common sense again, but common sense decisions that has resulted in banning safe products. How do you know the products are safe?
That comment related to the ability of the Commission to grant exceptions based upon data that was available to them. I mean, the Commission is not going to act to grant exceptions if there was exposure, as Mr. Howell testified, under the Federal Hazardous Substances Act to any hazardous substance. And then in terms of, so in that situation, the problem is not that the Commission can't make that determination. The problem has been that the language in the statute, which you now seek to correct, provides the Commission cannot make the decision if there's any lead that comes from the product. And that creates a catch-22. So what we're saying is that when the Commission can determine that there is no extractable lead from the product that presents a hazard, the examples of the ATV fender, the bicycle fender, brass latches on safety devices, maybe in car seats and strollers, when there's no actual human health risk, they should be able to say that these are exempt or excluded products.
Right.
So far, they can't. And the way we know, and the way, you know, many of our clients know they're safe is they do testing, they do extraction testing, they do formulations, they avoid hazardous substances where possible, because under the Federal Hazardous Substances Act, for children's products, they have to.
Thank you. All right, the balance of the time has expired. I will recognize Ms. Schakowsky for 5 minutes.
Thank you, Madam Chairman. I wanted to make it clear, particularly to Mr. Marshall, that Mr. Waxman, who at the time was the in April of 2010, who was chairman of the full committee, released a discussion draft that gave targeted relief to industry while maintaining important protections, which I'm sure you agree are important, for the health and safety of children brought about by this legislation. I was very involved in it at the time. Mr. Rush wasn't here for health reasons, and I helped negotiate the bill, and I worked with Chairman Barton. And afterwards, you know, things happen, and you see some problems, and so Mr. Waxman introduced this draft that would make some changes. And at the time, the draft was supported by the National Association of Manufacturers, the Retail Industry Leaders Association, the Motorcycle Industry Council, the Handmade Toy Alliance, and Goodwill Industries, and the Chairman Tenenbaum wrote that the Waxman discussion draft would provide CPSC with the flexibility needed to implement the law. And then at that time, the Republican minority refused to support the legislation, and it didn't move forward in the 111th Congress. So I want to make the point that we understand that there are some things that need to be tweaked. We want to do it, but we don't want to blow up the bill. This has been an issue so dear to my heart, and I did want to ask Ms. Weintraub an important question. The draft bill exempts most children's products, including durable nursery goods, which I've been working on for many sessions, from third-party testing, but then says that cribs will be tested. However, the current language remains ambiguous on cribs. Can you talk about this ambiguity? If the bill were to become law, could parents be assured that the crib they're using is safe?
Sure. Yes, I agree that there's ambiguity. On the one hand, in the list of products that clarifies that there is third-party testing, cribs and non-full-size cribs are included, but yet there's a reference to a CFR that seems to have moved, so it's a little bit confusing. But then further confusing, there's another provision later on, I believe it's in the third-party section, which says that this would stay all standards having to do with third-party testing that were passed since some date in 2009. So there's definitely confusion about whether cribs would be required to be tested to the new robust crib standard.
There's another part. The bill would eliminate the requirement that daycares and hotels in certain states use newer, safer cribs. And I wanted to read, I have subsequently become friends with Linda Ginzel, the mother of Danny Keyser, whose son died in a really tragic accident. And I had in my hand the letter from her that I wanted to read, just one paragraph. We founded Kids in Danger in 1998 after the death of our beloved son Danny in a poorly designed, inadequately tested, and recalled portable crib. Danny was 16 months old when the top rails of the play school travel light crib he slept in at his licensed child care home collapsed around his neck, strangling him. He was the 12th child to die in cribs of this design. So do we really, is it necessary to eliminate that requirement?
No, it's incredibly problematic. In terms of what the draft bill does for child care facilities, it seems to be allowing all fixed-side cribs, and the new robust crib standard does much more than eliminate drop sides. It adds many important provisions that ensure the durability of the cribs so that cribs can actually wear, reflecting how children use cribs. Has to do with slat integrity, has to do with mattress support and the integrity of the hardware. So by just saying that all fixed-side cribs can be used in daycares, it unfortunately isn't capturing the universe of those cribs that we have reason to be concerned about.
Let me just say in the seconds I have left, Madam Chairman, that I know that you care very much about the safety issues, and just I, for one, would love to be able to work with you to address some of the problems that we're hearing and to work to come up with some kind of a compromise.
I thank the gentlelady yields. I thank her very much for the spirit, and I look forward to working with you and acknowledge your expertise and your passion over the years in this. And I can say, I think there's already, just in listening to these past few seconds, I think there's some misinterpretation of this. But this is a draft discussion. I feel it's almost like a Mad Libs when we were kids. There are blanks in here for this very reason. And I would never dream of doing this without working with you. So I thank you very much for your comment. And now the chair recognizes Mr. McKinley for his 5 minutes.
Thank you, Madam Chairman. Ms. Weintraub, I've got a couple questions for you on the, apparently the chairman and others on the committee had asked you about substantiating the claims that children have been, quote, injured, sickened, or killed by toys with lead in its substrate. And you've responded that these injuries are by and large silent and undocumented. How do we know they exist if they're silent and undocumented? And could you provide us some documentation that supports this, that how many people have, and with names or circumstances?
We know that lead exposure to children causes a range of neurological problems.
I'm looking for some specifics because you made the statement. That's what I'm just trying to.
Yeah, so first,
I don't want the generalities. That's what happens around here. I'm new at this game, and everyone likes to talk in the abstract. I'm an engineer. I want to deal with details. So when you make that statement, I want you to prove it.
Sure. Well, first, the statement that I made applied to a full range of products. So when I talked about the injuries and deaths, I was also talking about magnet toy deaths as well as injuries from other toxic chemicals.
Can you document it?
It is very difficult to document when a child.
Then you shouldn't be making that statement.
I can provide you with scientific studies
I'd appreciate that. Let me go on. My second question for you was last week we had at the request perhaps of the or insistence of the administration and the congressman from California, we included language in a broadband oversight bill to take care of their the false and erroneously claims against people for waste, fraud, and abuse, and precisely to protect these companies' reputations. We use Congressman Waxman's own language that he had inserted in a radio spectrum bill that he introduced last year. So we were using specifics. And then last year there was a data security bill that the minority, the Republicans were trying to put into a consumer's right bill to protect the access to databases, protect it for security, for people's reputations. I've got a company in my area that has cried out on this. He's already had legal advice that is suggesting that he could be accused anonymously by people using false names put up there against him, and he won't be able to clear his name, his company name. So I'm just curious, shouldn't companies who manufacture consumer products not be provided the same ability to protect their reputations from erroneous or false claims as the companies who receive broadband, like we just did?
I think there are very similar protections, not identical, but first of all, on the consumer complaint database, complaints cannot be anonymous.
Is that something that you think we should be doing? Shouldn't we be protecting everyone and not just certain
I think there are adequate protections already, and already, in order for a claim to be filed and posted on the database, a consumer needs to verify that what they're saying is true.
Council doesn't agree with you on that. That's why we need to do this language. We need to have something in there to be able to take care of that, because we're looking for something that's consistent with it. But the last question,
I'm happy to take a look at
Mr. Marshall, if I could back to you. You know, one of the things we were looking for in this hearing were some data, because there are a lot of blanks, and you heard the chairman talk about it. And on page 11, it says the term produced in small quantities means not more than blank number of units of the same product. What would you recommend as a number that we should use in that?
I think that could be a range of numbers. I think on an outside, I think 10,000 units per year would be the highest we'd like to see. 10,000 as the highest, yeah. But it has to do with...
and that's maybe I'm dealing more with your company, what you all produce.
Well, I own a toy store, and my wife and I, we buy from small batch manufacturers. Okay. So, but that's a number that we're willing to discuss. And
10,000.
We have a lot of, as a high number, that would be the highest that we would want to see that number. It could be a range of numbers below that as well.
Okay. Yield back my time.
I thank the gentleman, and seeing no other members present, I believe that we are now ready to wrap it up. I ask unanimous consent that these 16 letters be made a part of the record, all of which have been vetted previously by the minority without objection. All right, and as we wrap things up again, I want to thank our panelists for your patience today, your indulgence, certainly through this long series of votes. I'd like to thank you for your commitment to this very important issue. I look forward to hearing your thoughts further as we move this legislation forward. But I would like to be perfectly clear. Our only goal is to correct the unintended consequences of subsia. This draft does not undermine the current law. Again, we're trying to fix the problems that we know of in subsia, hopefully get some common sense back into this thing. We're simply working to make it better for all Americans and to provide the Consumer Product Safety Commission with the flexibility that it is asking for. As a mother with two children and 3 stepchildren, I'm completely committed, like everybody in this room is, to the safety of children everywhere. So I hope we can put these political differences aside and pass a bill that will make them prouder and safer. The ranking member and I continue to have discussions about our hope and willingness to work together to get a good bill through Congress that not only we can be proud of, but the American people can as well. So I remind members they have 10 business days to submit their questions for the record, and I ask the witnesses to please respond to any questions they receive, and the hearing is now adjourned. Thank you again.